ಆಡಿಯೋ ಆನ್ ಮಾಡಿ. ಇದು ಇದು
ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್
ಹಂಗೆ ಇರಬೇಕಲ್ಲ.
ಇವತ್ತು ಕ್ಲಿಕ್ ಮಾಡಿದ್ರೆ ಹೊರಟೋಗುತ್ತೆ.
ಸರ್ ಸರ್ ಸರ್
ರಜೆ
ಸರ್ ಹಿಯರಿಂಗ್ ಆನ್ ಅರ್ಲಿ ಯಾವಾಗ ಬರುತ್ತೆ ಸರ್? ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಹಾಕಿದ್ದೀನಿ ಸರ್. 16, 17. ಥ್ಯಾಂಕ್ ಯು.
ಇಲ್ಲ ನಾನು ಹೇಳೋದನ್ನ ಕೇಳಿಲ್ಲ, ನೀವು ಮಾತಾಡಿ, ಎರಡೂ ಮಾಡಿ. ಇಲ್ಲ ಸುಮ್ಮನೆ you comply first after the vision, then you move the memo. You take it. You mention it, madam, you have completed or not. First you mention that. Huh? Yes. Sir, ಏನು ಮಾಡೋದು? Then you have to before the court. ಆಯ್ತು ಬರುತ್ತೆ, ಕೇಳಿ ಮೆನ್ಷನ್ ಮಾಡಿ. ಇವತ್ತು ಆಗೋದಿಲ್ಲ, ಮೋಸ್ಟ್ಲಿ ನಿಮಗೆ 15 ಕೊಡ್ತಾರೆ. ಆಯ್ತಾಯ್ತು, ನೀವು ಮಾತಾಡಿ. For what purpose you are getting this now? It can't be here once again, sir. It is already been discussed. This was an impleadment. The matter is closed. We have to file another case.
ಸ್ವಲ್ಪ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ ಸರ್. ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಫೋನ್ ನಂಬರ್ ತಕ್ಷಣ ಫೋನ್ ಮಾಡಿದ್ರೆ ಈಸಿ. ನಮಗೆ ವಾಟ್ಸಪ್ ಮಾಡಿದ್ರೆ ಗ್ರಾಂಟ್ ಆಗಿದ್ರೆ ನನಗೆ ಕಾಪಿ ಕೊಟ್ಟರೆ ಆಯ್ತು. ಇವಾಗ ತಗೊಂತಾರೆ, ಆಮೇಲೆ ಮಧ್ಯಾಹ್ನ ಓಕೆ.
ಮಧ್ಯಾಹ್ನ ಇಲ್ಲ ಸರ್, ಮಧ್ಯಾಹ್ನ ಫುಲ್ ಎಕ್ಸಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನೋ ಪಾಸ್ ಅವರ್ಸ್. ಅಲ್ಲಿ AG ಎಲ್ಲ ಆಗಿದ್ದಾರೆ, ಬರ್ದಿದ್ದಾರೆ, ನೋಡ್ಕೊಂತಿದ್ದಾರೆ. ಪೂರ್ತಿ ಇದ್ರೆ ಯಾರು ನಿಂತ್ಕೊಂತಾರೆ ಅವ್ರನ್ನ ತೋರಿಸ್ಕೊಡಿ. ನಾನು ಹೇಳ್ತೀನಿ. ಆ ಕಡೆ ಗಿಡ ಇದ್ದಾರೆ ವಿಶೇಷ ಫಸ್ಟ್ ಇನ್ನು ಮಿಕ್ಕ ಸುಮ್ಮನೆ ಬಾಳಿಕೆ ಬಂದರೆ ತಗೊಂಡ್ವಿ. ಅದೇ ಅವ್ರು ಬಂದು ಅಡ್ಮಿಷನ್ ಅದು ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ 32 ಐ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಿಂಗೆಲ್ಲ ಇದ್ರೆ ಅದು ಆಫ್ಟರ್ 16 ಕೊಟ್ಬಿಡಿ. 16, 17 ಮೇಲೆ ಐ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಟೇಟ್ ಐತೆ ಅಂತ ಹಿಂಗೆ ಮಾಡ್ತಾರೆ. ಸ್ಟೇಟ್ ಐತೆ ನಮ್ಮ ಸ್ಟೇಟ್ ಐತೆ ಯಾವ ನೋಡಿ. ಅದು ಅರ್ಲಿ ಇದ್ರೆ ಇದು ಮಾಡ್ಬಿಡಿ. ಆಮೇಲೆ ನಮ್ಮ ಮೆಮೋ ಒಂದು ಬುಕ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಬರ್ದ್ಬಿಡಿ, ಕೊಡ್ತೀನಿ. ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲಿ ಬರ್ದ್ಬಿಡಿ, ಡೇಟ್ ಹಾಕ್ಬಿಟ್ಟು ಕೇಸ್ ನಂಬರು, ಡೇಟು, ಕೇಸ್ ಆಗೋಲ್ಲ ಮಾಡ್ತೀರಾ, ಬರ್ಬಿಟ್ಟು ಕಂಪ್ಯೂಟರ್ ಇದು ಮಾಡ್ತಾರೆ. ನಿಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಮೆಮೋಸ್ ಕೇಸ್ ನಂಬರ್ ಇದೆ ಇದೆ.
With your kind permission, sorry for it. The writ petition number 4181/2016 में, well also it was posted on 6/3/2020.
Please give it. Yes.
The matter call on 16. I know
Yes.
16. Please.
Adjournments, any other side to be present?
Yes.
Fresh matters, serial number 1.
Serial number 63. Seeking for an adjournment.
Who is on the other side?
Minutes, I'm appearing for respondent KDB.
63.
Please, Melas. 24th or 25th, Melas, if I may request.
24th or 25th?
25th, Melas, 25th.
63 at the request of learned counsel for petitioners. Release this matter on
25th, Mike.
24th,
by
Agni.
25th.
They'll have to furnish some documents to us.
Huh?
They'll have to furnish some documents to
Melas,
us.
learned AG is appearing in that matter, Melas. 24th is available, Melas.
24th.
Some inconvenience on 24th, my lord. 25th, your lordship. If it's convenient, your lordship.
We'll have it on 22nd then.
Well, it's 22nd,
Well-
senior counsel is not available.
Then after vacation. Yes.
Melas, may I request for 20th?
After vacation. Yes.
Melas, there is some urgency in this matter. Melas, it is heard partly, Melas.
Huh?
The matter is heard partly, Melas.
Ah.
Melas, may I request for to be taken on 24th, Melas? 24th or 25th, Melas?
24th, my lords, 24th.
20.
My lord, there's some
Yes.
Much obliged.
my lord, some
No, we will
inconvenience.
finish off on our.
What is this? Otherwise, we'll have it on 21st.
Melas, 21st AG is not there, Melas, that is fine.
You decide amongst yourselves.
24th, my
If it
lords,
is
24th.
24th,
not able
Melas.
to reach at a date, we'll have it after vacation.
24th,
Yes.
Melas, 24th.
Please go on. Ah. Informed that they have to be here.
I'll appear for the petitioner, my lord. Kindly, it may be taken up on 15th, my lord.
46 ah. At the request of learned counsel Sri P.B. Raju, release this matter on 15th. ah.
Please,
All
my
right.
lord, 15th.
Yes,
Your Honor, minus CRP, it is posted on 15/4. But due to extreme urgency, I would request this honorable court kindly to post the matter today afternoon, Your Honor. I
No.
already complied with all
Not
of
possible.
because the trial court has posted
Yes.
orders today, Your Honor.
no, 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 yes,
In most urgency, Your Honor.
No, no.
Otherwise, my CRP becomes infectious,
No, no.
Your Honor.
Serial number
how
1.
it will become infectious?
For me, today it is posted for orders
Ah.
for to break open the lock, and if he passes the orders, then I
No.
should be successful here, Your Honor.
Yes,
It may be taken as a last case, Your Honor, at
no,
least
no,
by 4
not possible.
Serial number 1.
Or at least by tomorrow, Your Honor, kindly post it for
Tomorrow
tomorrow.
it's not working, madam. What is
Yes,
this?
sir, the very next day,
Not
please,
possible.
Your Honor.
Yes,
Serial number 1. Rudresh VC.
No, Gallamma.
yes.
Kindly consider, Your Honor, requesting.
No, no, no,
Rudresh
Today,
VC.
last case, it can be.
no,
done.
no.
Serial number 1.
Serial number 1.
Rudresh VC.
Matter is called out. There is no representation for the petitioner. Release this matter on 17th of April.
Serial number 2.
I'm appearing for the petitioner, Your Honor.
Omran Ghulam Ahmed Khan.
Your Honor, we have filed this present revision petition seeking the revision of the order passed by the Honorable Trial Court by dismissing our application under 7 Rule 11, Your Honor.
Yes.
The Honorable Trial Court has observed,
Where is the plaint?
Your Honor, it is in Annexure B, Your Honor.
Page number?
Page number 80, page number 28, Your Honor. The respondent has filed this plaint by seeking mandatory and permanent injunction, Your Honor.
Yes.
Now, while the petitioners filed the 7 Rule 11 application, the structure that the plaintiff had sought, that the respondent had sought.
Structure, illegal construction.
Yes, Your Honor.
Over a portion of the property
Yes, Your Honor.
by means of mandatory injunction to restore the plaintiff's vacant physical
Possession, Your Honor.
Possession. Directing the defendants by means of mandatory injunction to remove the gate and waste materials.
Yes, Your Honor.
Order for permanent injunction.
Yes, Your Honor.
Yes.
Now, while that being so, Your Honor, the building which was there itself was demolished completely. So
Who demolished?
the petitioner has demolished it, Your Honor, because that belonged to him. That
Defendant.
Yes, Your Honor, the defendant. Yes, Your Honor. So the prayers that has been sought by the respondents have become infructuous, Your Honor. While that being the case, the Honorable Trial Court, in its observation in page number 24, Your Honor, paragraph number 10, page number 23, Your Honor, page number 6 of the internal number, it says that it is admitted fact that the defendants have demolished their building during the pendency of the suit. This is an observation made by the Honorable Trial Court, Your Honor. And thereafter,
What page number 6?
page number 23, Your Honor, annexure A.
Ah.
It is admitted fact that the defendants have demolished their building during the pendency of the suit. This is the observation made by the Honorable Trial Court, Your Honor. And thereafter, in paragraph number 10, in the subsequent page number 24, Your Honor, it goes on to say in the body of the plaint, the plaintiffs have alleged that the defendants have attempting to block the access of the plaintiffs, and also it appears from the plaintiffs there is.
Where are we reading?
Page number 24, Your Honor, paragraph number 10. Paragraph number 10, fourth line from the top, Your Honor.
Yes.
In the body of the plaint, the plaintiffs have alleged that the defendants have been attempting to block the access of the plaintiffs. And also it appears from the pleadings that there is not only dispute in respect to the boundary, but also there is a dispute with respect to the measurement of the properties. Now, that being the case, Your Honor, in the plaint, I request this Honorable Court to turn to page number 31, Your Honor. Annexure B. Paragraph number 7. Your Honor, there has been an amendment. They have sought a rectification of that particular portion, Your Honor. They have done it in 2014, whereas the property itself was purchased in 2004, Your Honor. After 10 years, they have come and they have made changes to the schedule of their sale deed, Your Honor. My contention is that I have been in possession ever since. I have not.
So there is a dispute anyway.
Yes, Your Honor. That being meets, Your Honor, this is pertaining to not pertaining to injunction, but it is pertaining to an
issue notice to the respondents.
Your Honor, I'm seeking a stay on the proceedings, Your Honor.
Internal 5. (23rd of April). The petitioners are also permitted to serve copy of the petition along with annexures on the learned counsel representing the plaintiffs before the trial.
Certainly, Your Honor.
Yes.
Number 3, SK Acharya. Let me pay further.
Miller, the 5 items of scheduled lands, Miller, page 15, Miller, the scheduled land. These are the items of land, Miller. By not notifying the petitioners for the owners, have produced the revenue record. Pardon, Miller. Page 15, Miller.
Scheduled land.
Scheduled land. This 5 item is subject matter of acquisition for the widening of the highway, Miller. I have produced the records, Miller, RTs at page starting from page 17 onwards. All the scheduled lands of this property still is in the possession and enjoyment of the petitioners, though it has been acquired for, Miller, in the award you will see. First one, my lord, I will take page 105, my lord. 105. 105 relating to survey number 168/1. You'll have to get it, my lord. Serial number 47, page 104. I award na serial number 47. You'll have to kindly see the survey number 168/1. You'll kindly see the reference. ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟ ವಿಸ್ತೀರ್ಣವು ಯಾವ ಯಾವ ಖಾತೆದಾರರ ಜಮೀನಿನ ಹಕ್ಕಿನಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ವಿಸ್ತೀರ್ಣ ಬರುತ್ತದೆ ಎಂಬ ವಿವರಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಈ ಕಾರಣದಿಂದ ಈ ಪ್ರಕರಣದ ಜಮೀನನ್ನು ಮೋಜಣಿದಾರರಿಂದ ಅಳತೆ ಮಾಡಿಸಿ ವಿವರವಾದ ನಕ್ಷೆಯನ್ನು ಪಡೆದು ಪರಿಶೀಲಿಸಿ ಅಧಿಕೃತ ಖಾತೆದಾರರಿಗೆ ಪಾವತಿಸಲು ಆದೇಶಿಸಿದೆ.
Absolutely no notice, my lord. And your lordship may kindly see, unconnected persons like my lord, Sampa, Girija, Madhava, Prakash, Ravindra. These persons have been notified, and my lord, this has been fixed, and they say that there is no records at all. I produced the RTC as on today also, it stands in the name of the petitioners Vimala and Sunanda. That is, I produced the document at annexure B onwards. Now, next survey number, your lordship, coming to, this is the 168 by 13P, 10.
Matter for reference then.
It's not matter, not notified, even the reference madilla, even notified madilla, and now they are damaging the property. Your lordship kindly say next property, your lordship kindly appreciate. Serial number 49, one ನಿಮಿಷ ನೋಡಿ.
Preliminary notification.
ಇಲ್ಲ ಮಾಡ್ಲಿಲ್ಲ. Even award ಅಲ್ಲೂ ಇಲ್ಲ, ನಮ್ದು ಮಾಡ್ಲಿಲ್ಲ. ಈಗ ಬಂದ್ಕೊಂಡು ಜಾಗದಲ್ಲಿ
preliminary notification issued when?
ಇಲ್ಲ. ಈ ಸರ್ವೆ ನಂಬರ್ಗೆ ನಮ್ಮ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ಬೇಕು ಇಲ್ವೇ ಇಲ್ಲ. ಈ ಸರ್ವೆ ನಂಬರ್ ಇನ್ಕ್ಲೂಡ್ ಆಗ್ಲಿಲ್ಲ. And you must kindly see serial number 50.
Not produced copy of the notification?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ನಮ್ಗೆ ಅದ್ರ ನಮ್ಮ ಹೆಸರೇ ಮಾಡ್ಲಿಲ್ಲ.
Why have you not produced copy of the notification?
ಇಲ್ಲ copy because this is the award is there, my lord.
Let us see.
Well, is the award is passed. I mean, kindly see serial number 50, my lord. 1 minute, my lord. Serial number 50. I will produce that, my lord. Serial number 50.
Done it.
They are ransacking the property. Arakanat plantations all there are destroyed.
Shetty is requested to take notice for all the respondents. Learned Counsel for petitioners is directed to serve copies of the petition along with annexures on the Learned Counsel for the respondents. Release this matter for preliminary
not to alter the nature of next
on 16th of April.
Please.
Next week.
Please
come.
Please.
Yes. Please serve a
could
copy.
Could it be called a connected matter is also then 15th minute. Connected one more matter is there 15th minute. 15th.
ಯಾವುದು?
ಅಲ್ಲಿ ಇದೇ ಮ್ಯಾಟರ್ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ 15th ಗೆ ಬರ್ತದೆ. ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಮೆಮೊ ಮೂವ್ ಮಾಡಿದೆ. ಹೌದು 15th.
All right, 15th.
15th.
All right.
Serial number 4, HN Baswaraju.
For appearing for the petitioner. Petitioner is an education society. Between 93, 94 to 95, 96, about 160 acres of land acquired by the state for the benefit of the petitioner education society. Acquisition is completed. Award was passed as early as in 1996-97. Almost all the landowners accepted the award, and my lord, nobody except few landowners, it's about 3 or 4, sought for a reference, and all other landowners have received the compensation even without endorsing the protest. Then my lord, only 3 or 4 landowners sought for a reference under section 18 of the Land Acquisition Act. Those matters are referred to the city civil judge Tumkur. Then my lord, the adjudication have taken place during 2020. After the adjudication, my lord, the compensation was awarded by the Land Acquisition Office or enhanced little more. Then my lord, the landowners who have not sought for a reference, they wanted to claim the benefit under section 28 capital A of the Land Acquisition Act. Then my lord, at one point of time, the Land Acquisition Officer taken a decision that there is a delay in approaching the reference court. Therefore, you are not entitled to invoke section 28 capital A of the Act. That order was challenged by landowners before this honorable court in the writ petition. Writ petition came to be allowed. Directed my lord, the re-examine the matter so far a delay and all other aspect is concerned. However, a finding was recorded by this honorable court that my lord, the time spent for obtaining the certified copy of the award passed by the civil judge to be excluded and computed for the purpose of limitation, thereafter take a decision. Now, Assistant Commissioner Land Acquisition who declined entertaining the proceedings, now it is there, it is pending on the file of the Land Acquisition Officer. Now, the question I have raised in this writ petition is, my lord, 1894 Act was repealed in 114/2014. The repeal is, my lord, section 114 of the new act. That repeal provision, my lord, I extract, could your lordship may kindly see the text of the repeal provision. My lord, may kindly go to page 20. the repeal and savings. The Land Acquisition Act 1894 is hereby repealed. 1 of 1894, save as otherwise provided in this Act, repeal under subsection 1 shall not be held prejudice or affect the general application of section 6 of the General Clauses Act 1897 with regard to the effect of the repeals. Then your Lordship may kindly see section 28A capital A, I extracted redetermination of the amount of compensation on the basis of the award of the court, wherein an award under this part, the court allows to the application any amount of compensation in excess of the amount awarded by the collector under section 11. The person interested in all other land covered by the same notification under section 4, subsection 1, who are also aggrieved by the award of the collector, who are also may, notwithstanding that they are not made an application to the collector under section 18, by written application to the collector within 3 months from the date of the award of the court record that amount of compensation payable to them may be redetermined on the basis of the amount compensation awarded by the court. This is the provision. This 1894 Act was repealed with effect from 1/1/2014. My Lord, section 6 of the General Clauses Act, my Lord, we have extracted, it appears. Yes, my Lord, may I kindly go to page 21. Effect of repeal is where this act or any fourth central act or regulation made after the commencement of this act repeals any enactment hitherto made hereafter to be made, then unless a different intention appears, the repeal shall not revive anything not in force existing at the time of which the repeal act takes effect. This is one. Second, affect the previous operation suffered, it would not be applicable. Affect any right, my Lord, clause C, privilege, obligation, liability acquired, accrued or incurred under any enactment, so repealed. The effect of, this is the effect of repealing is concerned. My Lord, the question of law I would like to raise with great respect to your Lordship says, acts have been altered or totally repealed. My Lord, the word accrued and acquired is concerned. Supreme Court have interpreted that some legal proceedings is required to be pending. Only anticipating somebody's result, I could get relief in future that would not amount to a acquired or accrued interest in favor of a person. My submission to Lordship is, because of non-seeking reference by those persons, Act came to be repealed. Savings is subject to what I read under section 6 of the General Clauses Act. Could it open for the other landowners to invoke section 28 capital A of the Land Acquisition Act? Is the question I have raised. Well, this question, according to me, is fully covered by the judgment of the Apex Court, 2019, 19 SCC, page 626.
You know, what is the prayer in this writ petition?
Prayer I sought for is, your Lordships may kindly see. Prayer, page 30 may kindly be seen. Issue it in the nature of social any other rate, declare that section 28 capital A of the Act available under 1894 Act shall not be enforced after the said Act is repealed under parliamentary enactment in Act Central Act number 30 of 2013, effect from 1/4/2014, as the claim made by the petitioner not even satisfied the savings as envisaged under section 114 subclause 2 of the Act. Accordingly, third respondent lacks inherent authority either to invoke section 28 capital A or to initiate improved proceeding. Then issue it in the nature of such any other rate to quash the proceedings initiated a third respondent.
You are aggrieved of what?
You
are aggrieved of what?
Aggrieved by not the order. Your Lordship may kindly see the entertaining the proceedings by the Assistant Commissioner, Land Acquisition Officer, page 125, annexure K. Could your Lordships, page 125, order your Lordships will get operative portion of the order at page 130. He rejected their application to reference under section 28 capital A. That order was attached page 130.
Why you are made a respondent?
Beg your Lordships.
Why you are made a
I
respondent?
am the beneficiary of the acquisition. I am the beneficiary of the acquisition. For my sake, land was acquired. I deposited the compensation as early as in 93-94. It is about 200 acres of land. Compensation determined, there is a compensation. Almost all the owners never sought for any reference under section 18. Only few owners may not sought for reference. The reference are adjudicated during 2020. Compensation has been enhanced. Now the persons who are not sought for reference, they wanted to avoid the benefit under section 28.
There is an order in their favor passed by this.
No, that was set aside by the High Court Annexure L, page 131. That is the reason I produced. That order was set aside and matter remitted back to the Assistant Commissioner, page 143. In that view of the matter, petition is allowed. 49/2021 Annexure D is so and so is passed with a direction to take into consideration amendments made in para 3 of the application with regard to the time consumed obtaining certified copy for the purpose of condoning the delay in filing and thereafter pass appropriate in accordance with law. Now matters are pending.
Correct.
And adjudication is going on before the
Correct.
assistant.
That is also in terms of the directions given by this court.
My lord, that is, delay is concerned.
Still considered.
My submission is the repeal, effect of the repeal, my lord, that is
Learned,
the reason they
AG
kindly see the judgment of the
Takes notice for response number 1 to 3. Issue notice to response number 4 to 93. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. We will consider.
Can I seek your lordship's indulgence, madam?
Not at
One
this time.
judgment at this, that for the, my sake, my lord, I would like to refer to.
Yes.
My sake, I would like to refer to.
Yes.
My lord, may I kindly go to 2019 SCC 626.
Yes.
My lord, paragraph 31 is the relevant report. It is in respect of principles of statutory interpretation. Page 650 of the judgment.
Yes.
There are distinction between, could you allow this, madam? Para 31.
Yes.
The distinction between what is and what is not a right preserved by the provisions of section 6 General Process Act is often one great fineness. What is unaffected by the repeal of a statute is a right acquired and accrued under it and not a mere hope of expectation as a liberty to apply for acquiring a right. A distinction is drawn between the legal proceedings for enforcing a right acquired or accrued and a legal proceedings for acquisition of a right. The former is saved, whereas the latter is not. In construing the identical provision of section 10 of the Hong Kong Interpretation Ordinance, Lord Morris is speaking of the Privy Council. Observe, it may be therefore that under some repealed enactment, a right has been given, but that in respect of it, some investigation legal necessary is necessary. Right is then unaffected, preserved. It will be preserved even if the process of qualification is necessary. But there is a manifest distinction between an investigation in respect of a right and an investigation which is to decide whether some right should be or should not be given, or a repeal of a former is preserved interpretation act. Then mere right to take, my lord, my last fourth sentence, mere right to take advantage of an enactment without any act done by the individual towards availing himself, that right cannot be the property, be deemed as a right accrued, or not to be understood, supporting the view that if steps are taken under a statute for acquiring a right, right accrues even if the steps taken do not reach the stage when the right is given, not to the set. Then your lordship may kindly go to 653 for a moment.
We'll consider, sir. Let them come. We'll
Then
consider.
interim
Not at
order may kindly be granted for a while,
No,
because this honorable court in contempt. 1
issue,
minute.
issue emergent notice to the
My
respondent,
endeavor.
returnable by 24th of April.
My endeavor this minute. Just
Let
one.
them come.
Few
Not
seconds I will take
Not
it.
at this stage.
Only few minutes of your
Yes.
lordship.
Next matter,
In
please.
the contempt, it is directed to dispose of the proceedings with 12 weeks.
Yes.
The time is going to be expired. That is the reason I sought for a limited interpretation.
No. I have given a date. Let it come up. We'll consider.
Date, my lord.
ಹೇಳಿದೆನಲ್ಲ.
24/4.
Yes.
4/4. Serial number 5, PN Vishwanath.
My lord, I will serve the copies on the government advocate for statutory respondents. My
That I
lord,
said.
they-
I've ordered.
They may not serve by that time, my lord. Anyhow, I will take steps today itself.
Yaro?
All are about 94 respondents are there, individual respondents.
The petitioners are also permitted to serve a copy of the petition along with annexures on the learned counsels representing the private respondents before the
Assistant Land Acquisition Office.
Land Acquisition Office. Yes.
Still number 5.
In this case, my lord, the land has been acquired for BMIC project.
Nice project, my lord.
28-1, 28-4 agide. No award has been passed. So the
learned AGA takes notice for respondents number 1 and 2. Learned counsel Sri P.V. Chandrasekhar, present in the court, takes notice for response number 3 and
3 to 5, my lord. 3 to 5.
BMICP.
Alla 3 to 4.
Are 3 and 4? Only 3 and 4.
No, 5 also, my lord. 5 also. Our officer, KADB.
3, 4, 5. 3 to 5.
And 6
learned counsel
Nitin Prasad.
Nitin Prasad is directed to take notice for response number 6 and 7. Learned counsel for petitioners is directed to serve copies of the petition along with annexures in the learned counsels for the respondents.
24.
Release this matter on 24th.
24.
Yes.
Number 6. Subramania S. Upasana.
In this manner, survey report has already been filed, my lord. This honorable court directed me to inquire about the grant at page number 15, my lord. Is the compensation is paid or grant is made, my page number 20, typed copy, my lord. In that itself, it was excluded. The acquired land was excluded and application was filed by the petitioner for re-grant. Under section 5 of the Mysore Village Officers Abolition Act, at page number 18. I have transmitted. I have not received the information with respect to grant, my lord. It is, we have to search, my lord. It was directed for me and for the petitioner to file grant certificate or grant which is made, my lord. I have sent the information. I have not yet received the information with respect to the grant of the above survey numbers, my lord, for the petitioner. I require some more time.
Request of the learned AGA.
Even the petitioner, if he has the document.
Release this matter.
Check it. I will check it.
On.
I also applied for
23rd of April.
Much.
Yes.
Serial number 7.
Bring for the petitioner, my lords, last. It is a writ of mandamus, my lords, wherein the land, my lands were acquired for the purpose of Bangalore Hassan broadgauge. I'm just asking for the reference, my lords.
Shri Gautam Dev Ullad, appearing for the second respondent, Southern Railways, submits that he has received copy of the writ petition this morning.
Yesterday, my lord.
And therefore, he needs some more time to secure instructions and make submissions.
My lords, in the meantime, I may be permitted to amend, my lords. My application may be allowed for amendment. On the last date of hearing, my lords, after hearing the matter for a while, this honorable court advised that the prayer has to be modified because I have sought only for consider the representation, but whereas specific so I have made an application for amendment of the prayer, which will not change the nature of the petition, my lords. I have as sought for directing the respondent to refer the case of the petitioner before the civil judge CJM at Magadi, Bangalore, for redetermination of the compensation amount, my lords. I'm making it little specific, so my IA may be allowed. In the meantime, I will carry out the amendment also.
Order on IA number 1 of 2025. This application is filed by the petitioner seeking to delete prayer number 1 while adding another prayer in its place, seeking a direction to the respondents to refer the case of the petitioner to the learned senior civil judge and CJM at Magadi, Bengaluru Rural District for the redetermination of the amount of compensation in terms of sections 18 to 28 of the Land Acquisition Act. Full stop. Learned counsel for the petitioner submits that no prejudice will be caused to the respondents if the application is allowed. Full stop. Next para. Having regard to the prayer made in the application, seeking to replace a particular prayer, it is clear that the nature of the case does not change and no prejudice will be caused to the respondents if the application is allowed. Full stop. Next para. Accordingly, IA number 1 of 2025 is allowed. Learned counsel for the petitioner is directed to carry out the amendment in the writ petition and furnish amended copy of the writ petition within a period of 1 week from today.
My lords, please. A date may be fixed, my lords. Date may be fixed.
For what?
For next hearing, my lords.
The copies.
Huh?
They have to serve the amended.
One prayer matra. Please give it now. It's that at least give a copy of the application.
Certainly,
so that they will know what exactly you're asking for.
My lords.
Release this matter on 24th of April.
Much obliged. Much obliged.
Right. Krishna has asked.
In this case, my lord, we have filed the detailed objection yesterday. I don't know whether that file is put up or not. It is not known. My lord. Yesterday,
it is for interim prayer, my lord.
So before that, my lord, I have to make submission.
Yes.
My lord, the petitioner is the owner of the land in survey number 162/2 and 234/2 of Lord Badaga Udupadi village, Mangalore Taluk. Lord, total 6 acres 16 guntas. Lord, the acquisition, Lord, the rubber industry is not established in both the survey number. Lord, kindly see the license as well as Lord issued by Panchayat and conversion order. My lord will find page 54.
But 2006 and 2010 notification.
Yes, my lord, award is passed 11/8/22 without notice to me. Award is passed on 11/8/22.
No, your name is not reflected in the notification.
But I have filed objection. I have filed objection, Lord. I filed objection. Award is passed on 11/8/22 without notice to me.
No. You should have challenged the final notification then.
But now I am questioning, my lord,
14 years
notification, but delay, Lord, delay on the part of the Lord, respondent. Also, Lord, should be viewed, Lord. After 16 years, Lord, award is passed.
For contention that the land could not have been notified for acquisition was required to be considered before final notification is issued. And they have issued the notification. So, you did not challenge it.
Lord, the law on the land is law on the land. I will make my submission, Lord.
My lord, other survey number, my lord, he has filed it and
I will make my submission, Lord.
165, my lord. This is 164. And they have filed the writ appeal. It is pending before the
status quo order is there. No, my lord, status quo will be granted. But I will make my submission.
What?
I am able to convince you, Lord,
number
delay is
165. 14 years, my lord, without the Banda Development Authority
15 years in passing award, Lord. That is what Supreme Court says recently.
Learned counsel.
But may I?
For the respondents, KD.
Yes, Lord.
Submits that similar issue was considered by this court in WP number 10983 of 2022.
Same notification, my lord, survey number 165. Now they have changed 164.
My lord, status quo order is there in the writ appeal.
Where the petitioner had filed a writ petition in the year 2022, calling in question notifications issued, the impugned notifications issued on 19/8/2006 and 8/1/2010.
8/10/2010.
8/10 ಅದು
ಹೌದು ಹೌದು
8/10/2010. Full stop. However, this court has dismissed the writ petition by order dated 12th of December 2023 while rejecting similar contentions that the petitioner had established a rubber industry
yes same
on the land in question, and therefore the land
No,
could
no,
not
Milord.
have been
No, 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 no.
notified for acquisition.
ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಅದರಲ್ಲಿಲ್ಲ.
ಅದರಲ್ಲೂ ರಬ್ಬರ್ ಪ್ಲಾಂಟೇಶನ್.
ಅದೇ ಪ್ಲಾಂಟೇಶನ್ ಇತ್ತು, ರಬ್ಬರ್ ಪ್ಲಾಂಟೇಶನ್ ಅಲ್ಲಿ.
Next para. Learned counsel would also submit that the statement of objections are ready.
Yes.
Filed. Stop. The same may be filed in the office.
ಫೈಲ್ ಆಗಿತ್ತು.
ಆಗಿದೆಯಾ?
Yes.
ಖಂಡಿಸಿ ಮಾಡಿ ರಿಟ್ ಅಪೀಲ್ ಆರ್ಡರ್ ಮಾಡಿ.
Learned counsel for the respondent KDB submits that the statement of objections have been filed in the office.
Yes sir.
Yesterday, while serving a copy of the same on the learned counsel for petitioner. Full stop. Release this matter.
Lord, 1 minute.
On.
But 1 minute.
21st of April.
Alla,
We'll consider.
Appeal stay ಇದೆ ಕೊಡಿ.
Consider.
Alla.
We'll consider and dispose of the writ petition itself. Please come on 21st. Yes.
22nd Milord.
All right, 22nd.
Not since there's a status quo order. No. Very respect, very land.
If the writ petition meets the same fate, you will also go before the division bench and ask for an stay. Yes.
But I don't think my lord will force me to go to writ appeal, since the writ appeal is pending.
If there is a inordinate delay in challenging the notification.
Supreme Court recently not on the very.
We'll consider. Yes.
Serial number 9, Basuraj Patil GK.
This matter, my lords, I served with the copy of the writ petition last week, my lords. I shall obtain instructions, my lord.
Not in the same status, my lord, preliminary hearing.
Huh?
In the same status, preliminary hearing.
Let us see. Yes.
This matter, the copy was served on me last week, my
At
lords.
the request of learned counsel for the respondent BDA.
Please.
Release this matter on.
Lords, 22nd, my lords,
21st of April.
Please.
All right.
Serial number 10.
More connected matters. Petition 506 of 25. The same.
Huh?
One more petition was not listed today. 506 of 25. Connected matters there. Will argue next week.
ಅವರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ.
ಹಾ.
ಇನ್ನು one matter ಹಾಕಿಲ್ಲ. So
ಯಾವುದು?
ಇನ್ನೊಂದು 506 ಅಂತ ಇದೆ. That was not listed today.
ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ವಲ್ಲ?
ಇಲ್ಲ.
ಹಾ.
Next week we will argue. Corrected matter. It may be along with.
List this matter along with.
506 of 25.
WP number 516 of
2025.
ಅದಾಗ್ಲೇ ಒಂದ್ಸರಿ ಬಂದಿದ್ಯಾ ಕೋರ್ಟ್ ಮುಂದೆ?
ಒಂದ್ಸರಿ
ಬಂದಿದ್ಯಾ? ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದ್ಯಾ?
ನೋಟಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆ. ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
On 21st of April.
Number 11. GR Lakshmipati Reddy.
Instructions. Huh? Want to take instructions? I need 1 week time.
22nd. ಆಗ್ಬೋದು. Yes.
I want to take instructions, my lord. It is the insofar as the Kauti layout is concerned.
As directed by this honorable court, I have served the copy.
Alternative site.
Yes, alternative site, madam. In earlier
revenue site. You are the owner of a revenue site.
Revenue site.
Then
he has to approach the committee.
The same order. ಅದು ಯಾವುದು ಇನ್ನೊಂದ್ರಲ್ಲಿ ಮಾಡಿದ್ರು ನೋಡಮ್ಮ.
The earlier
Justice Keshav Narayan committee to go before the Keshav Narayan committee.
In the earlier instance, this honorable court has already directed the petitioner to approach the committee.
ಮಾಡಿದ್ಯಾ?
They have produced the copy also here.
ಎಲ್ಲಿದೆ?
Page number 25, my lord.
Annexure F, I have produced page 25.
Reserving liberty to the petitioner to avail remedy of approaching the committee. ಆಗಿದೆಯಲ್ರಿ?
Yeah, in spite of that, they are not considering.
They have not.
So gone before the committee?
ಅಲ್ಲ ಇವರು BDA ಮೇಲೆ several annexure
They have
representations file ಮಾಡಿದ್ರೆ they are not cared.
They have.
Your lordship.
Liberty was given to you to approach the committee.
They have approached the commissioner. They have
Please
filed
see
on
page number 28.
Yeah, madam. Yes, madam.
Accordingly, petition is disposed of.
Reserving liberty to petition to avail remedy of approaching the committee and take benefit of the observation made so and so, my lord. But in,
What did you do?
in pursuance to that I have made representation to VDA annexes G to
G illari adu 2005 ಯಾವುದು
ಅವೆಲ್ಲ
ಹಳೇದು. What did you do after this?
Thereafter, he approached the commissioner, my lord. He filed on application.
ಅದನ್ನ ಫಾರ್ವರ್ಡ್
Yes,
ಮಾಡಬೇಕಾಗಿತ್ತು
ma'am.
ನೀವು.
We will forward it. I think it is
Forward
forwarded.
ಮಾಡಿ.
For that reason, only I have to take instruction, whether it is forwarded or not. I want to take instructions. Maybe
if they forward it, my lord.
The petitioner had earlier approached this court in WP number 41704 of 2019, and this court disposed of the writ petition on 13th of June 2023, reserving liberty to the petitioner to avail a remedy of approaching the Justice Keshav Narayana Committee and to avail the benefit of the observations made by the Honorable Division Bench. The division bench of single judge ಇದು
single judge. Single judge.
Single judge. Of the observations made in WP number 51929 of 2014. Full stop. The petitioner, the learned counsel for petitioner submits that accordingly, representations have been given to the Commissioner, Bangalore Development Authority on 19/10/2024. Full stop. However, no information is given to the petitioner either by the Commissioner, BDA or the committee. Full stop. Next para. Having regard to the facts narrated herein above, this court is of the considered opinion that if a representation is given by the petitioner to the commissioner, BDA, the commissioner is required to forward the same to the committee. Yes, ma'am. To enable the committee to take a decision in the matter. Yes. Full stop. Information regarding when the representation has been forwarded to the committee should be made known to the petitioner, so that the petitioner can approach the committee for redressal of his grievance. Full stop. Next para. The entire exercise shall be completed within a period of 4 weeks from the date of receipt of a copy of this order, ordered accordingly.
Number 12, Lokesh K.
This matter appearing for petitioners, Millard. Last date, Millard was directed the
passed
KD
an order
take
wherein there are
instructions.
objections have been considered and then the objections have been rejected also. I am passing the copy.
Millard. Object land admittedly, Millard, there is a big factory and my ancestors' thumbs are there, Millard. And
relevant page, my lord, is page number 13 and 16.
Two 23 ರಲ್ಲಿ ಆಗಿದೆ.
22 ನಲ್ಲಿ ಆಗಿದೆ ಸರ್. 22 ನಲ್ಲೇ they were considered.
7/8/2023.
Please, order ಆಗಿರೋದು, but objections was considered on 22 itself. Page 13 and 16, my lord. Serial number 140, survey number 73. ದಿನಾಂಕ 17/12/22 ಪ್ರಕರಣವನ್ನು ಕೂಗಿಸಲಾಯಿತು. ಖಾತೆದಾರರು, ಅನುಭವದಾರರು, ಹಿತಾಸಕ್ತಿಗಳು ಗೈರು ಹಾಜರಾಗಿರುತ್ತಾರೆ.
ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದೆ. ವಿಚಾರಣೆ ಖಾತೆದಾರ ಅನುಭವದಾರರು ಗೈರು ಹಾಜರಾಗಿರುತ್ತಾರೆ ಮತ್ತು ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ ಯಾವತ್ತೂ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಇರುವ ಆಕ್ಷೇಪಣೆ ಏನೂ ಇಲ್ಲವೆಂದು ಪರಿಗಣಿಸಿ ಈ ಸರ್ವೆ ನಂಬರ್ ಅನ್ನು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಲು ಆದೇಶಿಸಿದೆ.
Elri, how can you do that when they have stated that we have put up a brick industry?
That is in respect of another survey number that my lords will find it at page number 16. In respect of 100.
Yes.
At the bottom, my lord, serial number 237.
Yes.
107/2.
Yes.
So in that next page, 17th page, ಅದರಲ್ಲಿ second paragraph, Rangamma Kom late Ramabairegowda, Sunandamma who is a petitioner herein, ಎಂಬುವರು ಲಿಖಿತ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿ ಈ ಜಮೀನು ನಂಬಿಕೊಂಡು ಜೀವ ನಿರ್ವಹಣೆ ಮಾಡುತ್ತಿದ್ದು ತೆಂಗು, ಅಡಿಕೆ, ಬಾಳೆ, ಮಾವು, ತೇಗ, ಶ್ರೀಗಂಧ, ಹಲಸು ಮರಗಳಿದ್ದು ಪುರಾತನ ಕಾಲದ ದೇವಾಲಯ ಮತ್ತು ಸಮಾಧಿಗಳಿದ್ದು ಈ ಜಮೀನನ್ನು ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಕ್ರಮದಿಂದ ಕೈ ಬಿಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ದೆನ್ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಆಕ್ಷೇಪಣೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈ ಜಮೀನಿನಲ್ಲಿ ಇರುವ ಮರ ವಿನ್ಯಾಸಗಳು ಸೂಕ್ತ ಪರಿಹಾರವನ್ನು ನೀಡುವುದರಿಂದ ಹಾಗೂ ಈ ಜಮೀನು ಉದ್ದೇಶಿತ ಯೋಜನೆಗೆ ಅತ್ಯವಶ್ಯಕವಾಗಿ ಬೇಕಾಗಿರುವುದರಿಂದ ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಇರುವ ಆಕ್ಷೇಪಣೆಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಲು ಆದೇಶಿಸಿದೆ. That objection in respect of the presence of a small temple and the graves of the ancestors has been considered, then it has been rejected.
Alri, where is the consideration regarding the establishment of the big factory?
That is not stated.
That is not been forthcoming, my lord.
Where is your objections?
My lord,
that is not, they are not annexed with the petition, my lord.
Objections is not placed, my lord. But documents produced before the court clearly indicates.
Court munde.
Court munde ide, there also we produced.
Where is it? Where is your objection?
The same photographs produced before.
Where is your objection, sir?
Objection is not given by the party.
You can't try to take advantage of the orders passed by the court in respect of some other person. And if the benefit was given to all similarly placed persons, that they may once again give a representation and the SLAO would reconsider that one.
The circular, my lord, indicates two survey points, my lord. One is ancestor thumbs are there, it cannot be acquired. That is also circular 2007.
Adu,
yes,
that is,
yes.
If it is not possible to give up those lands for the sake of contiguity, then the objection can be overruled.
Two circumstances I am seeking, my lord. One
big
is
factory, as you said,
big factory is there. It is
on that ground.
Yes.
If the neighboring lands have been denotified, or they have left out of the acquisition proceedings,
that is there
on the same ground.
Ground, my
you
lord,
also can avail that benefit.
My first ground, my lord, is may kindly look at page 13, para 9 of page 9, para number 13. 134, 135 and 136 adjacent land abutting to this survey number has been excluded from the acquisition proceedings, and that is my one of the first ground, my lord. And moreover, my lord, the purposefully, my lord, they have not shown the
yav layout idu,
my lord,
yav layout ke,
my lord, it is not for KIDB industrial area, my lord. Industrial area, my lord.
Illi
Machenahalli,
Sompura, Milord, there are in my property, Milord, there are 400 arcanite trees and borewell and Anjaneya Swami old temple, and my father's ancestors' thumbs are there.
Now you please read the circular.
Circular, Milord, may kindly look at page number 44. May kindly look at, Milord, circular page 44.
Yes.
Relevant page, Milord, is 45 and second one, Milord. ದೇವಸ್ಥಾನ, ಸ್ಮಶಾನ, ಶಾಲೆ ಮತ್ತು ಆಟದ ಮೈದಾನ ವಾಸನಕಾರಿ ಸೂಚನೆಯಲ್ಲಿ ಸೇರಿಸಬಾರದು. ಅಂಡ್ ಕ್ಲಾಸ್ 5 ಕೈಗಾರಿಕೆಗಳಿಗೆ ಪೂರಕವಾಗಿರುವ ಆಸ್ಪತ್ರೆ, ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಮತ್ತು ಇತರ.
ಪ್ಲೀಸ್ ರೀಡ್ ದಿ ಬಾಡಿ ಆಫ್ ದಿ ಸರ್ಕ್ಯುಲರ್.
ಮೇಡಮ್, KDB 28/4 ಅಡಿ ಅಂತಿಮ ಸೂಚನೆ ತಯಾರಿಸುವಾಗ ಮೇಲೆ ಹೇಳಿದ ಜಮೀನುಗಳು ಹೊರತುಪಡಿಸಿ ಅದರಲ್ಲಿ ಯಾವ್ದು ಅಂದ್ರೆ ತೋಟಗಳು, ಫಲವತ್ತಾದ ಜಮೀನು, ವರ್ಷಕ್ಕೆ 2 ಬೆಳೆ ಬಾಳುವ ಜಮೀನುಗಳು, ತರಿ ಜಮೀನುಗಳು ಸೇರಿದೆ ಅಂತದನ್ನು ಬಿಡಬೇಕು ಅಂತ ಇದೆ. ದಟ್ ಈಸ್ ಸರ್ಕ್ಯುಲರ್.
ಓದ್ರಿ, ಸರಿಯಾಗಿ ಓದ್ರಿ. ನೀವು ಏನೋ ನಿಮ್ ಇಷ್ಟ ಬಂದ ಓದ್ಬೇಡಿ.
KDB ವತಿಯಿಂದ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕೆ ಏಕಘಟಕ ಸಂಕೀರ್ಣಗಳಿಗೆ ಜಮೀನುಗಳನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುತ್ತಿದ್ದು ಈ ಕೆಳಗಂಟ ಪ್ರಕರಣಗಳಲ್ಲಿ ಸರಿಯಾಗಿ ಪರಿಶೀಲಿಸದೆಯೇ ಕೆಡಿಬಿಯು ಜಮೀನುಗಳನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುತ್ತಿರುವುದು ಸರ್ಕಾರ ಗಮನಕ್ಕೆ ಬಂದಿದೆ. ಕೆಡಿಬಿ ಕಾಯ್ದೆ 28 ಕಲಂ 28(1) ಅಡಿ ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ದೇವಸ್ಥಾನ, ಶಾಲೆಗಳು, ಸ್ಮಶಾನಗಳು ಮತ್ತು ವಾಸದ ಮನೆಗಳು ಸೇರಿರುತ್ತವೆ. ಹಾಲಿ ನಡೆಯುತ್ತಿರುವ ವಿವಿಧ ಕೈಗಾರಿಕೆಗಳು, ರೋಗಸ್ಥರ ಕೈಗಾರಿಕಾ ಘಟಕಗಳು ಹೊಂದಿರುವ ಜಮೀನುಗಳು ಸೇರಿರುತ್ತವೆ. ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಿಗಳು, ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಅನುಮೋದಿಸಲ್ಪಟ್ಟಿರುವ ಜಮೀನುಗಳು, ಸರ್ಕಾರದ ಭೂ ಸ್ವಾಧೀನ ಒಳಗೊಂಡಿರುವ ಜಮೀನುಗಳು, ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಭೂ ಪರಿವರ್ತನೆ ನೀಡಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಜಮೀನುಗಳು ಸೇರಿರುತ್ತವೆ. ಕೈಗಾರಿಕೆಗಳಿಗೆ ಪೂರಕವಾಗಿರುವ ಆಸ್ಪತ್ರೆ, ಪೆಟ್ರೋಲ್ ಬಂಕ್, ಇತರ ಮೂಲಭೂತ ಸೌಲಭ್ಯಗಳ ಪ್ರದೇಶಗಳು, ಜಮೀನುಗಳು ಸೇರಿರುತ್ತವೆ. ತೋಟಗಳು, ಫಲವತ್ತಾದ ಜಮೀನು ಹಾಗೂ ವರ್ಷಕ್ಕೆ 2 ಬೆಳೆ ಬೆಳೆಯುವ ಜಮೀನುಗಳು, ತರಿ ಜಮೀನುಗಳು ಸೇರಿರುತ್ತವೆ. ಕೆಡಿಬಿ ಕಾಯ್ದೆ 28/4 ಅಂತಿಮ ಅಧಿಸೂಚನೆಯನ್ನು ತಯಾರಿಸುವಾಗ ಮೇಲೆ ಹೇಳಿದ ಜಮೀನುಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಕೆಡಿಬಿ ಕಾಯ್ದೆ ಕಲಂ 4 ಅಡಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಲಾಗುತ್ತದೆ. ಇದರಿಂದ ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ಅಂತಿಮ ಅಧಿಸೂಚನೆ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಉಂಟಾಗುತ್ತಿರುವುದರಿಂದ ಸರ್ಕಾರಕ್ಕೆ ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಮೇಲೆ ಹೇಳಿದ ಲೋಪದೋಷಗಳನ್ನು ಸರಿಪಡಿಸಲು ಕೆಡಿಬಿ ವತಿಯಿಂದ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕೆ ಏಕಘಟಕ ಸಂಕೀರ್ಣಗಳಿಗೆ ಜಮೀನುಗಳನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಲು ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆಯನ್ನು ತಯಾರಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಕೆಳಕಂಡ ವಿಧಾನವನ್ನು ಇನ್ನು ಮುಂದೆ ಪಾಲಿಸಲು ಈ ಮೂಲಕ ಸೂಚಿಸಲಾಗಿದೆ.
ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
2013 that is covered the judgment.
Why have you not produced that circular?
That was not within my knowledge. Later onwards, my lord,
But I shared that copy with you.
that after they are
Yes.
my lord, I came to
I have considered this one and I have passed orders.
Objection. Yes, my lord. My submission before the court, my lord, is that the 18/3/2013 circular, it is subsequent circular by this honorable court, my lord, the procedure, my lord, wherein also, my lord, Tengu, Silver, Athara, the para number 7, I may be permitted to read, my lord, in the judgment, my lord. While 28(3) objections filed, wherein also, my lord, in survey number in that case, my lord, particularly 155/1, I may be permitted to read that para 7, my lord.
You know?
Para 7 of the judgment, my lord, in the judgment. Yes, my lord. Paragraph 7, my lord.
Yeah.
Perusal of the objections filed by the petitioners at annexure would indicate that apart from specifically contended that lands were being used for agricultural activities, they have also given details of existence of buildings, existence of trees, nature of trees, 5 active borewells which are existing in the land being used for agriculture purpose. In this, the contrast of the reasons assigned by the respondent LAO at column number 25 of the under order section 28(3) of the act.
Where is the consideration of this subsequent circular?
Subsequent circular, my lord, is para number 10, my lord.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
Is also appropriate to refer the circulars issued by the respondent state government, circular 1/3/2007 that I produced. Circular number so and so dated 18/3/2013, second circular. Where, my lord, the similar circumstances they have excluded, they have to follow the, while filing the objection, once filed objection under 28(3), the requirement.
What has been said about circular dated 18/3/2013? I have considered this.
The para 11 says, my lord,
copy right now I do not have. In fact, my lord, their objections what they have submitted, in that they don't mention
said,
about.
Yes.
In the earlier notification, this is what we had said, but later on we have found that because of this circular, there are islands formed in the industrial area, which is not be permissible in law. Therefore, even if such objections are raised, but for want of the lands for maintaining contiguity of the industrial area, that objections can be rejected.
But
you can't have an island of private property in an industrial area. Not possible.
But even in their objections, they don't mention about existence of the brick factory. Because it's very clear, I've got a copy of it, where they only speak about the existence of the tombs as well as the trees.
About para 11, my lord, the honorable court held, my lord, para 11 final conclusion, my lord.
Sir, they have not considered what has been said in 2013 circular.
But court held, my lord, para 11.
I have held it, and I have to be consistent.
Circulars indicate that respondent state itself has recommended the exclusion of the lands which falls under the.
For the respondent KDB is directed to furnish copy of the subsequent circular dated 18/3/2013. Released this matter on 21st of April.
My endeavor, my lord, factory is there, my lord, some protection, my lord.
That objection is not come in, my lord, in their objections what they submitted to the department.
And you have not even furnished copy of your objections.
I will furnish next.
Yeah, in the meanwhile,
I
the
will
learned
furnish the
counsel for
objections.
petitioner shall also furnish copy of the objections,
Filed.
if any, filed by the petitioner before the SLA.
Great.
Yes.
Date.
13,
21st.
number 13, M. Sudhakar Pai.
I beg to appear for the petitioner, my lord. Sought for a direction, this matter, my lord, to respondent number 1, especially on the competent authority, to refer the matter to the civil dispute, to the civil court, as provided under section 3H of the National Highways Act.
Why none of them have come?
Mr. P. Prasad, my lord, was directed to take notice. Next day itself, I served on him and filed an acknowledgement. No. NHA ಎಲ್ಲ ಅದು ನ್ಯಾಷನಲ್ ಹೈವೇ ಡಿವಿಷನ್ ಅಂತ ಇವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಇನ್ ಹರ್ ಪ್ಲೇಸ್ ಮೆಲಾರ್ಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಡ್ ಡೈರೆಕ್ಟೆಡ್ ಮೆಲಾರ್ಡ್ ಆನ್ 24/3 ಮೆಲಾರ್ಡ್ ಪಿ ಪ್ರಸಾದ್
ತೋರಿಸಿದಾರಲ್ರಿ ಹೆಸರು.
ಹೌದು, ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಲಿಲ್ಲ ಅಂತ ತಾವೇ.
ಅದೇ matter is called out. There is no representation for respondent number 1. Although the name of learned counsel Shri B. Prasad is shown in the cause list. Full stop. Release this matter on 16th of April.
Would it be on 17th?
17th.
Grateful.
Please inform him.
P, my lord. It's not B Prasad, my lord.
P. Prasad. P. Prasad.
P for pen.
Last line tagbiಟ್ಟು, however, learned AGA submits the name is P. Prasad.
P. Prasad ಅನ್ನ ಸರ್ ಮಾಡಿ.
P for peacock. ಇಲ್ಲಿ B ಹಾಕಿದ್ದಾರೆ.
Oh, okay. I have not observed.
Office is directed to show the name of the learned counsel correctly as P. P for peacock. P. Prasad.
Yes.
For respondent number 1. Release this matter on 17th of April.
Interim order, my lord.
Interim order granted earlier stands extended in the next date.
Grateful.
So 14, Satyanarayana.
I'm for the petitioner.
Yes.
My lords, on the last occasion, I was directed to take notice. Petition copy is not served on me, my lords. I'm not aware of the.
I served in the office, my lord.
ಯಾವ ಆಫೀಸ್?
BDS office. BDS office.
ನಾವು ಇವ್ರಿಗೆ ಹೆಸರಿಗೆ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಕೊಡ್ರಿ ಅಂತಂದ್ರೆ ನೀವು ಅಲ್ಲಿ ತಗೊಂಡೋಗಿ ಕೊಟ್ರೆ?
ಅಲ್ಲ, ಅರ್ಲಿಯರೇ ಕೊಟ್ಟಿದ್ದೆ, ಅವ್ರು ಸಿಗ್ಲಿಲ್ಲ ಅಂತ. ಸತ್ಯಾನಂದ ಅವರು ಸಿಗ್ಲಿಲ್ಲ ಅಂತ.
Counsel for the petitioner is directed to serve a copy of the petition along with annexures on learned counsel Shri Vinayak S. Pandit, who appears for the respondent BDA. Release this matter on 16th of April.
That's 17th.
17th.
Much obliged.
Serial number 15, N.S. Siraj.
Lords, 79 A and B proceedings, Lords. I purchased the property in 2007. Lords, in 2008, Lords, they passed an order for forfeiting the lands. Lords, that is under challenge, Lords. Annexure B.
Annexure B, page 20, ma'am.
Which are those orders that I have passed?
Lords,
don't have a copy?
I don't have a copy, Lords, but the impugned order, Lords, you get annexure B, page 22.
ನೀವೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕ್ರಿ.
Order ಇದೆ.
How many hundreds of orders have passed?
Your Lordship has passed orders.
I will furnish.
Learned AGA takes notice for both the respondents. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Release this matter on 16th.
Yes.
If you don't get it, please ask the court officer.
Pass over if it is passed over also. 2:30 I will.
No, it's all right. Let it come on 16th.
16.
Yes.
Serial number 16, Venugopal MS.
Petition is for a direction to early disposal of the claim proceedings before the trial court. 2010 is the acquisition, my lords. 13 is the reference
I know.
under 3H.
2013.
Oh, 13 reference.
Milord, we have deposited amount in the
Why
court.
does it take so much of time to dispose
Because
of
there
the?
is a
But it's
rival
Milord
claim.
court.
my
We are Milord, we have nothing to do. We have deposited money, Milord. Now, like the court has to decide that who is entitled for the compensation amongst the respondent.
Oh, there are private.
Private respondent.
Yes.
The petitioner is aggrieved of the fact that the reference made by the Special Land Acquisition Officer and competent authority NHAI in LAC number 2 of 2013 has not been disposed of for more than 12 years now. Full stop. Therefore, the prayer in the writ petition is to direct the learned additional senior civil judge and JMFC at Devanarli to decide and dispose of the reference within a time frame. Next para. Learned counsel for the first respondent NHA has no objection to allow the writ petition and issue directions to the learned judge. Full stop. Next para.
Milord, I appear here for SLO, Milord. This one number 1 is SLO.
Having regard to the innocuous prayer made in the writ petition, the writ petition stands disposed of with the direction to the learned so and so to consider and dispose of the reference as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order.
Please, sir.
Non-compliance for first time. Raja Ramesh.
Cyril, I am for the petitioner, my lord. Petitioner's property was acquired for the purpose of widening of road.
No, non-compliance of office objection.
One short objection, one short time.
Each time is granted.
Also,
at the
ma'am.
request of learned counsel for petitioner for complaints of office objections.
Much obliged.
Seal number 18, Chetan DT.
A week's time is granted.
Seal number 19, TN Vishwanatha.
A week's time is granted at request.
Seal number 20, CM Nagbhushana.
Petitioner, there are 4 office objections. I request your lordship to overrule objection. 1, 2 and 3. First one chronological order in one day date correct ಮಾಡ್ಕೊಡ್ತೀನಿ. 2 and 3 your lordship may overrule. As far as the 4th objection is represented by superintendent of police and I will do it, your lordship. ಇದರಲ್ಲಿ supplementary award ಮಾಡಿ district themselves for 1 acre 83 guntas. I have produced that. 1 acre is left out as per the order of the commissioner.
You made a correction, we will have it next week in any of the 3 days. Please correct it.
Correct ಮಾಡ್ತೀನಿ ನಾನು ಏನಂದ್ರೆ
we will have it next week. ಏನು ಅಂತ urgency ಏನಿದೆ?
Urgency ಏನಂದ್ರೆ land acquisition officer, revenue department, they are not rising. The police officers, the task force ನವರು notice ಕೊಟ್ಟು will demolish possession ತಗೊಂತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Your lordship may kind enough to take annexed 95, page 95, your lordship. Suchana
notice. What is your contention?
Our contention is 1 acre is not taken over. There is a record. I have produced it, your lordship. It is 2 acres 24 guntas nalli 1 acre 10 guntas only they confine on the orders of the commissioner. 1 acre is left out, and which 1 acre is left out, there is a sketch, your lordship. I have produced that sketch at page 94. But this police task force, they simply one.
Please come to the synopsis.
Yes, your lordship.
2001 preliminary notification.
Yes, your lordship.
Adralli 2 acres 12 guntas
ಮಾಡಿದ್ರು and award 2 acres 12 guntas ಮಾಡಿದ್ರು. Later on, your lordship, they confined that itself for only 1 acre 8.3 guntas. That your lordship may kind of take page 33, your lordship, 33 and 34. As per the orders of the commissioner dated 6/9/2000, compensation of 1 acre of land is restricted as follows ಅಂತ ಮಾಡಿ ಅದನ್ನ ಅಷ್ಟಕ್ಕೆ ಮಾಡಿ 1 acre 12 guntas ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಡಿಪಾಸಿಟ್ ಮಾಡೋದು 1 acre 12 guntas ಮಾತ್ರ.
Supplementary note.
ಹೌದು.
ಅಲ್ಲಲ್ಲ.
It is as per the orders of the commissioner.
Where is the final notification?
Final notification is made for 2 acres 12 guntas. Even award is passed, your lordship. Your lordship may kindly take page number 25 to 32. Page number 32 ತಗೊಂಡ್ರೆ 2 acres 12 guntas ಕೂಡ award ಮಾಡ್ತಾರೆ. Subsequently confine themselves only for 1 acre 10 guntas. Compensation is deposited only for 1 acre 10 guntas.
Page number 32.
32 ನಲ್ಲಿ ತಾವು ತಗೊಂಡ್ರೆ 2 acres 12 guntas ಗೆ award ಮಾಡ್ತಾರೆ. Later on, your lordship will kindly say, as per the supplementary note, they confine themselves for 1 acre 12 guntas. 1 acre is left out, and your lordship, to that effect, they give an endorsement to me at page 39, your lordship. Page 39, annexed G, your lordship. Last sentence ತಾವು ಓದು ಸಾಕು. ಈ ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ 46/2ರಲ್ಲಿ ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನಿನ ಭೂ ಸ್ವಾಧೀನ ಅದು ಯಾತಕ್ಕೆ ಅಂದ್ರೆ we have challenged the acquisition, your lordship, because they requested second defendant to withdraw the writ petition. We will not acquire 1 acre. On that basis, we have withdrawn the writ petition, your lordship.
But where is the order?
What is the order, your lordship?
That the other extent of land is dropped from the acquisition proceedings.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅನ್ನೋದು ತಮ್ಗೆ ಗೊತ್ತಾ ಇರೋದು. 1 ಎಕರೆ ಜಮೀನ ಭೂ ಸ್ವಾಧೀನ ಪಡೆದಿರಲಿಲ್ಲವೆಂದು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿದೆ.
How can they say so if the notification shows that extent of land?
Your lordship will kindly see.
And that order has to be passed by the state government.
Your lordship.
Where is the order of the state government?
State government has passed an order, but the BDA has not taken 1 acre for possession, and they have accepted that we are in possession and we are developed, your lordship. How can the task force can take action against us, sir?
They are asking you for giving the documents, requisite documents. Please give the documents.
We have given the documents, your lordship.
Berkeley.
The documents ಎಲ್ಲ ತಗೊಂಡು ಕೊಟ್ಟಿದ್ದೀವಿ.
ಈ ತರದ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಗಳು subsequently they will come and disown it.
ಇಲ್ಲ, they can't your lordship.
We can't go by these documents. Therefore, there has to be an order passed by the state government dropping the proceedings in respect of a certain extent of land, unless you produce that.
Plan ಕೂಡ 1 acre ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನು ಸ್ಕೆಚ್ ಹಾಕಿದ್ದೀನಿ ತಮಗೆ.
We will see. You produce those documents, we'll see.
I have produced the sketch also, your lordship.
Sketch alla order passed by the state government.
State government has not passed an order.
Illa. There is no dropping of the proceedings.
Your lordship will kindly see, if the beneficiary says, I don't want this 1 acre, and it has not formed sites and everything, allowed us to develop it, your lordship.
K. Krishna is requested to take notice for response number 2 and 3. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for response number 2 and 3. Full stop. Next para. Release this matter. On 23rd of April 2025.
Third respondent shall be restrained.
The petitioner is directed to furnish
I am furnished
all the requisite documents as sought for in the impugned notice.
Yes, your lordship.
To respond number 3.
Third respondent may be restrained.
Respond number 3 shall not proceed any further.
Yes, sir.
Till the next date of hearing.
Very well.
Yes. In the meanwhile, office
In
objections.
fact, annexed L ಪ್ರಕಾರ ನಾವು documents ಕೂಡ ಕೊಟ್ಟಿದ್ದೀವಿ.
Office objections at serial number 1 and 4 shall be complied with. Office objections at serial number 2 and 3 are overruled.
Yes, ma'am.
Yes.
Much obliged.
21, R. Srinivas Gowda.
I am for the petition. Two objections, my lord. One is DCF, my lord, it's paid yesterday, my lords. ಅದು DCF 100 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕಾಗಿತ್ತು, ನೆನ್ನೆ ಕಟ್ಟಿದೀವಿ. ಇನ್ನೊಂದು KDB ಕಾಪಿ ಸರ್ವ್ ಮಾಡಬೇಕು ಅಂತಿದೆ, ಅದು ಈಗ ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಸರ್. ಅಷ್ಟೇ ಎರಡೇ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
Type copy to be attested.
ಅದೇ ಅದೊಂದು ಅಷ್ಟೇ ಇನ್ನೇನು ಮಾಡ್ತೀನಿ. ಅದಕ್ಕೆ ಬ್ಲಡ್.
Yes.
Blood. The land is bloods proposed to acquire for the connectivity road of ITIR layout bloods. Annexure B is the notification bloods. Annexure C is the notification. For that, not the petitioners have filed objection stating that blood there is the road is formed in the other lands of the same village bloods, and this land is not required for the formation of the road bloods. Annexure F is the objections bloods. That those objections have not been considered by the land acquisition officer. I have produced the sketch of the road that is formed in other survey numbers, and this road and my land is intersected by the Raj Kalve. Raj Kalve, our road farm road nam land madhya Raj Kalve hogide, so that our land is not required for the extension of any road or layout bloods. This is our land is at extreme edge of the that layout bloods. 28.3 enquiry, there is no reference of consideration of our objections. It is at page number 32, my lords.
ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಏನು ಗೊತ್ತಾಗಲ್ಲಪ್ಪ.
ಅದೇ ಇದು ನಾನು ABCD ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದ್ನಲ್ಲ ಪೇಜ್ ನಂಬರ್ 42 ಅಲ್ಲಿ, ಅದು ರೋಡ್ ಮಲಡ್. ಅದು ರೋಡ್ ಫಾರ್ಮ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನಮ್ದು ಎಕ್ಸ್ಟ್ರೀಮ್ ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಅದ್ರ ಮಧ್ಯೆ ನಮ್ ಲ್ಯಾಂಡ್ಗೂ ಮತ್ತು ಈ ರೋಡ್ಗೂ ಮಧ್ಯೆ ರಾಜ್ ಕಾಲುವೆ ಇದೆ ಮಲಡ್. ಬ್ಯಾಡ್ರಳ್ಳಿ ಕೆರೆಗೆ ಹೋಗುವಂತ ಇದು ಕಾಲುವೆ, ರಾಜ್ ಕಾಲುವೆ. ನಮ್ದಾದ್ಮೇಲೆ ಯಾವ್ದು ಲ್ಯಾಂಡ್ ಇಲ್ಲ, ಇಟ್ ಇಸ್ ಅನ್ ಐಲ್ಯಾಂಡ್. ನಮ್ ರೋಡ್ ಮಾಡಿದ್ದಾರೆ, ಮಧ್ಯೆ ರಾಜ್ ಕಾಲುವೆ ಇದೆ, ಅದಾದ್ಮೇಲೆ ನಮ್ ಲೆಫ್ಟ್ ಗೆ ಲಾಸ್ಟ್, ಮತ್ತೆ ಯಾವ್ದು ಆ ಕಡೆ ಲ್ಯಾಂಡ್ ಇಲ್ಲ.
ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂಡ್ ಫಾರ್ ವಾಟ್ ಪರ್ಪಸ್?
ITIR ಮಲಡ್ಸ್ ಅಪ್ರೋಚ್ ರೋಡ್. ITIR ಇಂಡಸ್ಟ್ರಿಯಲ್ ಲೇಔಟ್ ಇದೆ, ಅದಕ್ಕೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ಇಂದ ಅಪ್ರೋಚ್ ರೋಡ್ ಮಾಡೋದಕ್ಕೆ ಅಂತ ಮಲಾಡ್ಸ್. ದಟ್ ಈಸ್ ದಿ ಪರ್ಪಸ್ ಫಾರ್ ವಿಚ್ ಇಟ್ ಈಸ್. ಪೇಜ್ ನಂಬರ್ 15 ಮಲಾಡ್ annexure C. ಈ ಕೆಳಕಂಡ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದಿಸಿರುವ ಜಮೀನುಗಳು ITIR ಕೈಗಾರಿಕಾ ಪ್ರದೇಶ ಯೋಜನೆಗೆ ಸಂಪರ್ಕ ಕಲ್ಪಿಸುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಬೇಕಾಗಿದೆ. Road is formed in other survey numbers, survey number 99, 64, and other survey numbers.
When did they form?
After acquisition, bloods.
Then where is the photographs?
Road farm ಮಾಡಿರೋದಕ್ಕೆ. Producers, ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ. Road farm, they have farmed the road. They are using that road.
Learned AGA takes notice for respond number 1. Learned counsel Shri
H.N. Vasudevan.
H.N. Vasudevan, who is present in the court, takes notice for response number 2 and 3. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for response number 2 and 3. It is the next para. It is the contention of the learned counsel for petitioners that after the impugned notifications of acquisition the proposed road was formed, is formed, and no part of the land belonging to the petitioner in survey number 22/5B2
and 22/5B.
22/5B measuring 34 guntas and 22/5B2 measuring 39 guntas have been utilized for the purpose of formation of the road. Full stop.
Annexure L is the sketch.
Next para. Learned, the respondents. The respondent KDB. The third respondent SLAO is hereby directed to inspect the spot, conduct an inquiry, and submit a report before this court, meeting the allegations made by the petitioners, along with photographs. Next para, release this matter on 23rd of April.
Much obliged. Till then.
ಏನಿದೆ ಮಾಡಿದಾರ ರೋಡ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತೀರ
Yes, yes.
Cinema 22, Karan Joseph.
Petitioners Counsel. Office objection is, my lords, the final notification, only extract has been produced, which is relevant for us. I'm told, my lords,
Annexure A.
Annexure A notification. That is, my lords, 30th November. This entire Venkateshwara layout anta they had proposed. My lords, this honorable court, my lords, they have dropped the acquisition in the sense they have not proceeded. Way back in 2014 itself, this honorable court has recorded that Annexure E, page 49 only.
You please furnish the entire copy.
The acquisition.
You are raising a challenge.
Only so far as my land is concerned.
ಹಂಗಾಗೋದಿಲ್ಲ.
ಆಯ್ತು, ಅದು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಷ್ಟೇ.
Please furnish.
That we will furnish.
Learned senior counsel appearing for the petitioners submits that the
entire
certified copy of Annexure A completely will be furnished within a period of 3 weeks. 3
ಬೇಗನೆ
weeks.
ಮಾಡ್ತೀವಿ.
ಆಗುತ್ತೆ, ಸಿಗುತ್ತೆ.
Before that only. But if your lordship just sees Annexure E.
Yes.
At page 49, my lords.
What is it?
My lords, the land of the petitioner was sought to be acquired.
The scheme has lapsed antana?
Lapse anta idu made illa Venkateshwara layout anta. We have produced the photos also to show all the surrounding lands are developed now by the private parties. Illi front portion, my lords, there was one factory known as Torino factory anta. That is the petitioner. Photos tav nodidre gottagutte. And this court has held, my lords, where BDA has candidly recorded that the scheme itself has lapsed. In fact, the photos which we have produced, the drone photos are also there to show at page 56 onwards, my lords. Or your lordship may kindly come to page 65, my lords. Top view is there, 65 only. That factory premises, old factory premises, your lordships can see. That is not acquired. Behind that, my lords, your lordships will see there is a big building in Adar Munde ira jaga. That was the subject matter of acquisition.
Adar Munde andre road in Nakadega.
Lords, the metro track your lordship sees.
Iveradru madhya.
Haudu. Hindugade matra small portion they acquired. Hindugade no acquire madidru. That has now the private party has built the building. Right side and left side ಅಲ್ಲಿ VRL bus ಅವರು stand ಮಾಡಿದ್ದಾರೆ. If your lordship come to page 67, it gives a better view. A building, whatever is that old building which your lordship sees.
ಇವು ಎರಡು ಬಿಲ್ಡಿಂಗ್ ಮಧ್ಯ ನಾವು.
ಅದ್ರ ಹಿಂದ್ಗಡೆ ಪ್ಲೀಸ್ ಮಿಲರ್ಸ್ ಆ ದೊಡ್ಡ ಬಿಲ್ಡಿಂಗ್ ಮಲ್ಟಿ ಸ್ಟೋರಿ ಅದ್ರ ಮಧ್ಯೆ ಇರೋದು ಅಕ್ವೈರ್ ಆಗಿರೋದು. This was not acquired. This was notified. They dropped because Al Torino factory neditittu anta. Now somebody has constructed in the back. The east, west, north, south, everything is privately developed. And this court has said the acquisition itself has lapsed. Scheme is not implemented. Anta judgment kottiyare at page 49 minutes. 51. It starts at 49 in respect of the very same layout at page 50 and 51, your lordship. For Venkateshwara layout. And at 51, my lords,
Scheme itself is lapsed.
Huh.
So now, my lord, we were not aware. Our name stands, Kata stands in our name. Land is converted. Only when we are about to sell this land, we seek for an NOC. At that point, we come to know that they have not dropped the proceedings and it shows. That's why we have filed the present rate.
Learned AGA takes notice for respond but to first to state ಬರಬೇಕು ಆಮೇಲೆ BDA ಬರಬೇಕು ಅದೇನ್ ಮಧ್ಯ ತಗೊಂಡು ಸ್ಟೇಟ್ ಹಾಕಿದ್ದೀರಾ
ಮಧ್ಯಲ್ಲಿದ್ದಾರೆ ಅವರು ಹಿಂದೆ in between 1 and 3 state ಬಂದ್ಬಿಟ್ಟು
ಅದೇ for the respondent state learned counsel Shri B Vachan is requested to take notice for response number 1 and 3. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for the respondent BDA. Full stop. Next para.
Krishna idre Krishna gotu.
Learned senior counsel Shri K.N. Panindra appearing for the petitioners submits that as long back as 2014, this court has declared in writ petition number 43674 of 2013 that the scheme for formation of Venkateshwara layout with a preliminary notification dated 29/12/1988 and final notification dated 30/11/1990 has lapsed on account of the inaction on the part of the BDA. Full stop. Nevertheless, when the petitioners are seeking to dispose of their property,
NOC endorsement,
it has come to their notice that the lands in question are still shown as acquired by BDA. Stop. Next para.
All the 4 sites are privately owned now. It's an island.
Release this matter on 23rd of April 2025. Full stop. Learned counsel for the respondent BDA shall secure instructions and make submission.
Please.
Full stop. ಅಷ್ಟೇ ತರ
Interim order ಕೇಳಿದೀವಿ not to dispose.
Yes.
Anyway, we are in possession, my lords.
Yes.
23, Vasant Kumar HT.
Petition is. The office objection is the e-auction notification is not in larger. Small is unable to, is not in readable.
ಅಲ್ಲ ಆಫೀಸ್ ಅಲ್ಲಿ ಇಲ್ಲ please give it in the office.
Yes, ma'am.
Yes.
I'm challenging the e-auction notification under.
Learned counsel for the petitioner submits that better copy, better and enlarged copy of annexure M is ready.
Yes, ma'am.
And the same will be filed in the office.
Yes, ma'am.
Yes.
Yes, ma'am. No, the on site bearing number 163/1632 measuring 40 into 25 feet was allotted to my vendor Srimati Kavya. The allotment letter was issued on 28/9/2018 and is may kindly be seen also. Thereafter, my lord, the absolute sale was executed in favor of my vendor on 16 January 2019 and B may kindly be seen. After executing the sale deed, my vendor turned to sell the same site in favor of me through registered sale deed and C may kindly be seen. I have purchased the said site from my vendor Srimati Kavya on 13/9/2021. Thereafter, my lord, the said site is concerned the jurisdiction of both Bengaluru Mahanagara Palike. The Kata, I have been paying the revenue tax to the BBMP. BBMP has issued a Kata extract in my favor. Another F may kindly be seen of F, G and H. Thereafter, my lord, there is a adjacent marginal land to adjacent to my site bearing 1632 bar B, 1632A was adjacent 370 square feet adjacent to my side, marginal land, for which, my lord, I made representation on 19/3/2025 with annexure K to allot the same site to me, because it is adjacent to my side. There is no access to that site, hence I made representation to allot the same site in front of me. My lord, without considering my representation, all of a sudden immediately they issued the e-auction notice, auctioning the both sides, as well as my side, as well as the marginal land.
Your site.
Yes, my lord. Even without issuing any prior notice, my side and adjacent site 370 square feet, both 1,370 square feet, they are auctioning. Auction has been conducted, no notice has been issued. The fifth respondent is the highest bidder. Now they are going to execute the sale deed as per the e-auction notification. They themselves have executed the sale deed in respect of site number 1632 bar B. When I made representation to grant the allot the marginal land, immediately they have conducted the e-auction, including as well as the my site, to auction the both corner site as well as my site, 1,370 square feet, which is already auction has been conducted. The fifth respondent highest bidder, he has paid the 25% of the deposit amount. Hence, if the interim is not granted,
Where is that
yes, ma'am.
Site notified in annexure M?
Yes, ma'am. ಅದನ್ನ ಕೊಟ್ಟಿರ್ತದೆ ಇದು ಎನ್ಲಾರ್ಜ್ ಇದೆ, ಅದು ಈಸಿಯಾಗಿ ನೋಡಬಹುದು.
annexure M ಅಲ್ಲಿ.
ಎಸ್, annexure M ಅಲ್ಲಿ ಸ್ವಾಮಿ ಕೆಳಗಡೆ ಅದನ್ನೇ ತಾವು ನೋಡಬಹುದು, ದೊಡ್ಡದಾಗಿದೆ ಅಂತ ಹೇಳಿದೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 124.
ಇದನ್ನೇ ದೊಡ್ಡದಾಗಿ ಮಾಡಿದೀರಾ?
ಅದಕ್ಕೆ ಕೊಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 124 ನಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 1633 ಬಾರ್ ಎ ಎರಡು ಸೇರ್ಬಿಟ್ಟು 1633 ಬಾರ್ ಎ ಮಾಡ್ಬಿಟ್ಟು 1,370 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮಾಡಿದ್ದಾರೆ ಕೆಳಗಡೆ. ಮೈ ಸೈಟ್ ಇಸ್ 1632 ಬಾರ್ ಎ, ಸಾರಿ ಬಿ,
ಸೀರಿಯಲ್ ನಂಬರ್
124 ಅಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 1633 ಬಾರ್ ಎ 1,340 ಸ್ಕ್ವೇರ್, ಅಂದ್ರೆ 127 ಮೀಟರ್, which is including my site also. Immediately I made representation not to execute any sale deed because my site also involved in the auction. If the e-auction proceeding is not stayed because other than multiple proceeding will arise, they have to again they file the suit for cancellation of sale deed motion.
This cannot be accepted. What is shown in the sale deed is 1632 bar B.
Yes, ma'am.
Measuring 40 into 25
feet. Yes, ma'am.
That is not shown in the.
No, that is not shown in the, including 370 square feet as well as the my measurement. 1,340 square.
Where do you get that?
1,127 meters, which is
127, 1,000 Allah.
It's
only 127.40.
Yes, this comes under the 1,370 square feet.
That is 1633 bar A.
ಹೌದು ಅದು ಹೊಸ ನಂಬರ್ ಕೊಟ್ಟು 1,370 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲ, ಅವ್ರು ಇಲ್ಲ ಅಂತಂದ್ರೆ ಮೈ ಸೈಟ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಮಾಡೋಣ. If they are executed the sale deed, it's very difficult to prevent my case.
How can they execute a sale deed in your?
Because the fifth respondent is highest bidder, he has participated in the e-auction.
You put up a building?
No, my lord, there's a vacant site.
Vacant site?
Yes, my lord, that's what.
Barkali. Learned counsel, Shri Gautam Dev Ullal is requested to take notice for response number 124.
Yes. 5 is the
notice bid. To respond for 5. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned counsel for respondent BDA. So next para. Although it is sought to be contended on behalf of the petitioner that site number 1632/B, which was allotted by BDA in favor of the vendor of the petitioner, and a sale deed was executed in favor of the vendor of the petitioner on 16th of January 2019, and the same is now put up for e-auction in terms of annexure M, this court finds that the site number shown in the e-auction notification is 1633/A, totally measuring 127.40 square meters. Full stop. So prima facie, it appears that the petitioner that there is no basis for the apprehension of the petitioner. Full stop. Nevertheless, the respondent BDA is hereby directed to ensure that the property bearing survey number bearing site number 1632/B, which has been purchased by the petitioner from the rightful allottee at the hands of the BDA, no transaction shall take place pursuant to annexure M.
Please.
Yes.
Annexure M, my lordship, not N.
Annexure M.
M. I'm sorry,
M
I thought N. Great.
Sorry, I will वापस को Please take this.
Serial number 24.
Yeah, I'm for petitioner, my lord. 1 week time might be granted, my lord.
Sound control.
Non-complaint second time.
Finally, a week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Much obliged.
25. Except the notification. A portion order was produced here. They seeking entire notification, but
Complete copy of annexure J.
annexure J notification something. Notification of the portion order in the land acquired.
Okay, complete copy ಕೊಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
Complete copy.
Annexure J.
Annexure J. A page number ಏನಪ್ಪ ಅಂತ ಅದರಲ್ಲಿ ಲ್ಯಾಂಡ್ ಕೂಡ acquire ಆಗಿದ ಬಗ್ಗೆ ಏನಪ್ಪ ಅದು ಇದೆ. ಆ portion ಅಲ್ಲಿ annexure J ಇದೆ. ಆ portion ಕೊಟ್ಟಿದೆ. Last page 56 2A 52/6 serial number 290 Reddy in Ramaya Reddy Prathama 290 serial number 290
Office objection is overruled. Learned ACA takes notice for respond number 1. Learned counsel Shri Murugesh Charati is requested to take notice for respond number 2.
3 to 5 are private parties.
Issue notice to response number 3 to 5.
Yes.
Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for respond number 2. Yes.
After the notice, Murtike after the notice.
Bharat. Yes.
For 26 Murtike.
All the office objections are complied, except the highlighter cannot be removed. This is a certified copies. Annexure A and B as the certified copies, my lord. Highlight by mistake. By mistake. Highlight marking remove madaka.
Office objection is overruled.
As per the court order, unnecessary parties are removed, my lord. as per the court order, unnecessary parties cannot, I will be removed, madam, already removed.
Unnecessary?
Previous unnecessary parties ಇದು ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಮೂಡ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2, 3, 4, 5 regional commissioner, president, commissioner and special land acquisition officer was made as a party, my lord. Only special land acquisition officer, Mysore urban development authority has to be made, my lord. They have made another 3 unnecessary parties. Commissioner is also okay, but another 2 regional commissioner and president was also made as a party before this honorable
amendment ಮಾಡಿ ಹಾಕಿದ್ರ ಇದನ್ನ.
ಹೌದು
ಬಟ್ ಪ್ರೆಸಿಡೆಂಟ್ ಮೈಸೂರು ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಅಂತ ಇದೆ.
ಡಿಲೀಟ್ ಹೊಡಿಬೇಕಾಯ್ತು, ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಹೋದ್ಸತಿ ಡಿಲೀಟ್ ಮಾಡಕ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ವಿ, ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ. ಸೆಕೆಂಡ್ ಅಂಡ್ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಎಲ್ರಿ ಬರ್ತಾರೆ, ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಎಲ್ರಿ ಬರ್ತಾರೆ ಮೂಡ ಅಲ್ಲಿ.
I will remove. I will remove.
That is what I had directed.
Yes, ma'am.
ಅದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಕ್ರೈಬ್ ಆದ್ರೂ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೆ, ಅದು ಮಾಡಿಲ್ಲ ನೀವು.
Sorry, my lord. I will remove.
Respond number 2 and 3 has to be removed.
3 ಹೆಂಗ್ರಿ? 3 is Commissioner Mysore Urban Development Authority.
No, 3, 4 is
ಇದರಲ್ಲಿ ಇವಾಗ ಇರೋದ್ರಲ್ಲಿ
ಕರೆಕ್ಟ್ ಮಾಡಿದೆ.
At the ಬರ್ಕೊಳ್ಳಿ, at the oral request of the learned counsel for petitioner, respond number 2, the president, Muda is directed to be deleted from the array of parties. ಹೇಳಿ.
Writ of certiorari, annexure A and B, as per the Muda authority has issued a annexure A and B in the year of 91-92, my lord. But till now they are not taking any possession, my lord. I have the petitioner is a
Wash annexure
A and B, my lord. Notifications, my lord. A preliminary notification and final notification, madam.
Learned AGA takes notice for respond number 1. Learned counsel Sri T.P. Vivekananda is requested to take notice for respond number 2. Muda issue notice to respond number 3. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for respond number 2. Muda. Yes.
That might be they have, sorry my lord, they have made a wrong parties subsequently. The land acquisition officer was there, my lord, before.
ಅವರು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಕೊಟ್ಟಿರೋದು ನನ್ನ ಹತ್ರ ಇದೆ, ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ. Yes.
Orders number 27.
Offer for petitioner, my lord. Offer for petition, Paradan to my lord, appear in VC, sorry, my lord. My lord, I have filed a memo, my lord, dispensation for respond number R2, R3, R6, R8, R9 and R10, my lord. ಇದರಲ್ಲಿ R3 by the first respondent has filed a miscellaneous petition, my lord, for restoration of the suit. That came to be allowed against that order, my lord. This CRP is filed. Rest of the parties are, the defendants are, no relief is sought against them, my lord, in this. And in the cast title, my lord, today I have seen, my lord, respond number 6, 8, 9, 10 I already served, my lord. Only in respect of R3, R2, 3 and 6, kindly held sufficient.
From where did you get this information? Who are served?
Right side, my lord, right side column, in the cast title. Title R8, served Chandrika, V Chandrika, served, R9 served, R10 served.
ನೋಡ್ರಿ ಎಲ್ಲಿದೆ ವೆರಿ ದಿಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಅಲ್ಲಿ ಇವರೆಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ ಅನ್ಬಿಟ್ಟು R7A B C D ಮತ್ತೆ R8 R9
R10.
R10 R11 R12 ABC ಎಲ್ಲರಿಗೂ ಸರ್ವ್ಡ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
Lord, in the respond number 1, Lord, has already settled the matter, Lord. They have to come and say, already settled. They have also executed relinquished deed in favor of the parties, Lord. The respondent has to come.
ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್?
First respondent. She is the petitioner in miscellaneous petition.
ಏನಾಗಿದೆ?
ಅದರಲ್ಲಿ there was a
suit has been settled.
Suit has been settled. In the not this suit, my lord. What happened, my lord? She has filed another suit in OS number 1036 of 2001, where, my lord, settled. The settled before dishonorable court in, my lord, in criminal petition.
ಎಲ್ಲ ಸರ್ವಾಗಿದೆ ಎಲ್ಲ.
R2, R3 and R6 not there.
Learned counsel for the petitioners submits that Learned counsel Shri Kalyan R has entered appearance for respondent number 1, who is the contesting respondent, being the petitioner, who had filed a miscellaneous petition number 25225 of 2011. Full stop. All other respondents are co-respondents along with the petitioners. Full stop. The office note shows that all of them have been served. Full stop. Nevertheless, learned counsel submits that the parties have amicably settled the matter in another suit filed at the hands of respondent number 1. Full stop. Next para. Release this matter on 24th of April 2025 to enable the learned counsel for petitioners to place on record the decree drawn in terms of the settlement
not decree
parties or the first respondent may also file any such information or memo seeking disposal of the CRP. Yes.
Great. Kindly extend the interim. Kindly extend the interim.
Interim order granted earlier stands extended till the next date of hearing.
Great.
Still number 28, Siddhappa BM.
Appearing for petition, Your Lordship.
This is this.
Pay for a short accommodation. This R3, it can be taken as could be taken as abated, Your Lordship. R3 has passed away. He is not a contesting party, and all other respondents have been served, Your Lordship. Your Lordship has asked to file dispensation memo. All ಎಲ್ಲರಿಗೂ ಸರ್ವಾಗಿದೆ ಲಾರ್ಡ್ಶಿಪ್ ಅದರೊಳಗಡೆ ಎಲ್ಲರಿಗೂ ಸರ್ವಾಗಿದೆ. R3 ಗೆ ಮಾತ್ರ ಸರ್ವಾಗಿಲ್ಲ. ಅವರ ಡೆತ್ ಆಗಿದ್ದಾರೆ. Can be taken as abated. Can be taken as abated. He is not a contesting party. Posted for arguments, I pray for short accommodation.
Learned counsel for the petitioner submits that respondent number 1 herein, Shri K.T. Tippeswamy is the plaintiff in the suit, and all other respondents are co-defendants along with the petitioners herein in the suit, and no relief is claimed against them in this CRP. Full stop. Moreover, all the other respondents are also served and are represented by learned counsel Sri Y.H. Vijay Kumar. Full stop. It is informed that respondent number 3, Srimati Mallamma, is no more. Full stop. Learned counsel for the petitioners would therefore submit that the CRP may be dismissed insofar as respondent number 3 is concerned as abated. Next para. The submission of the learned counsel for petitioners is placed on record. Next para. At the request of learned counsel for petitioners, release this matter on 22nd of April. Yes.
29, Keshoyam Datar.
Appearing for the petitioner. The respondent had appeared in person on the last occasion. He's present before court. He's not filed a wakalat as well. If I may.
ವಕಾಲತ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ ಇನ್ನು?
If I may.
ಅಲ್ರಿ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ಸಕ್ ಆಗ್ಲಿಲ್ವೇನ್ರಿ? ಅವರೇ ಮಾಡ್ಬೇಕಾ? ನೀವು ತಂದು ಹಾಕೋದಾಗಿತ್ತಲ್ಲ. ಹಿಂಗೆಲ್ಲ ಸುಮ್ನೆ ಟೈಮ್ ಕೇಳಬಾರ್ದು. ಲಾಸ್ಟ್ ಆಪರ್ಚುನಿಟಿ ನಿಮ್ಗೆ ಬರ್ಕೊಳ್ಳಿ. Although the respondent was present before this court on the previous date of hearing and sought for a short accommodation to ensure wakalat is filed on behalf of the respondent, nevertheless, the respondent is once again present before this court seeking for some more time. Full stop. Next para. Release this matter on 21st of April. Full stop. If the respondent is not represented by a learned counsel, this court will proceed to hear the petitioner and pass orders.
Grateful.
Yes. 21ನೇ ತಾರೀಕು ನಿಮ್ಮ ವಕೀಲರು ಬರಬೇಕು. Yes.
Serial number 30, 14% HR Ramanna, non-filing of. Obligations, non-compliance.
ಏನು
ಸರ್?
ನೀವು ಸ್ಪೆಷಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಹೋಲ್ಡರ್.
ಎಸ್ ಸರ್.
ನೀವು ಅಪೇರ್ ಆಗಕ್ ಬರಲ್ಲ.
ಸರ್.
ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡಿ.
ಸರಿ.
At the request of the power of attorney holder of the petitioner, 2 weeks time is granted to ensure that wakalat is filed on behalf of the petitioner. Yes.
Thank you, sir.
Serial number 31, A. Sampath, survey report.
For respond number 2 and 3, my lord. Maybe 1 week time granted for report, my lord.
Report?
Yes, my lord. Survey report file next date.
LAO has to file an affidavit, my lord. Survey was directed for me to conduct a survey. As it is a BDA area, without assistance of the LAO, survey cannot be conducted. So they were directed to file an affidavit along with all those things.
Yes, my
lord. In fact, on the last
time may be granted.
Lords, in the last occasion, sorry, my lords. On the last occasion, my lords, I've given them all the judgments.
In fact, they were also directed, my lords, to look into it, make submissions. My lords, those records, my lords, that I have produced clearly shows, my lords, that there are several survey numbers adjacent to this land has been denotified, my lords, by an order of this honorable court. Therefore, my lords, they were supposed to make submissions. My lords, whether they filed the affidavit or not, for several years, my lords, they have not been doing it. My lords, request a date could be fixed.
Despite the learned counsel for petitioner furnishing information pertaining to all the petitions where the acquisition proceedings in respect of BSK 6th stage have been quashed, and this court directing the respondent SLAO to verify the information and make submissions, learned counsel for the respondent BDA seeks for some more time, full stop. This apathy on the part of the respondent SLAO in verifying the information next para, released this matter on 21st of April, full stop. This court will proceed to consider the submissions made on behalf of the learned counsel for petitioner regarding the earlier writ petitions where this court has quashed the impugned acquisition proceedings and pass orders, even if no information is forthcoming from the respondent SLAO or any submissions not being made on behalf of the respondent BDA. At any rate, please ensure that you verify that the information which is already given and make submissions. Otherwise, I'll dispose of the writ petition. Yes.
Obliged.
Number 32, Rajeshwar PN, P124, amendment of Constitution.
In the course of the day, I will carry out the amendment, my lord. My lord, I filed an early hearing application, my lord. 1969 is the preliminary notification, my lord. After 50 years, my lord, final notification is passed in the year 2019. My lord,
amendment
compensation, please, my lord, I will carry out.
The cost title is carried out.
In the course of the day.
Release this matter
Tomorrow, Wednesday, my lord.
on 16th of April.
Please.
All right.
See number 33.
33, I am appearing for the petitioner. Service to R4 may kindly be awaited, my lord. Notice hogide, service to R4 may kindly.
Service of notice.
Now it is between me and.
It is not furnished to either me or to the other.
Korteni.
How can we?
Copy korteni. Korteni, copy korteni. ಕೊಡೋದಕ್ಕೆ ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದೆ ನನ್ನ ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು ಕಾಪಿ ಕೊಡೋದೇನು ತೊಡದಿಲ್ಲ ಈಗಲೇ
1 year
for the respondents. However, submit that they have not received copies of the writ petition.
ಇಲ್ಲೇ ಇದೆ ಕೊಡ್ತೀನಿ ಈಗಲೇ ಕೊಟ್ಟೆ ಪೇಡ್ ಸರ್
ಕೊಟ್ಬಿಡಿ ಇವಾಗಲೇ ಕೊಟ್ಬಿಡಿ
ಈಗಲೇ ಕೊಡ್ತೇನೆ ನಂಬರ್ ಹಾಕ್ತೇನೆ ಕೊಟ್ಟು ಬಿಡ್ತೇನೆ ಹತ್ತುಗಳು ಒಂದು
learned counsel has now furnished copies of the writ petition along with annexures to learned counsels for response number 1 and 3.
ಕಾಪಿ ಕೊಡ್ಬೇಕು
ನಿಮಗೂ ಬೇಕಾ
1 and 3 ತಾನೆ ಇನ್ಯಾವುದು
ಅದು ಮೆಟ್ರೋಗೆ ಅವ್ರು ರಿಪೇರ್ ಆಗ್ತಾರೆ ನಾನು ಹೇಳಿ
ನಿಮಗೆ ನೀವು ಯಾರಿಗೆ
ಅಲ್ಲಲ್ಲ ಮೈ ಕಲಿಂಗ್
ಕೊಟ್ರಲ್ಲ
ಹೌದು
ಒಂದೊಂದು ಕಾಪಿ ನೆಕ್ಸ್ಟ್ ಪರ ಆಯ್ತು ಎಸ್
ನೀವಿಬ್ರು ಒಂದೇನಾ
Admission number 34, Srinivasa week.
I seek for a short accommodation. Rejection of R7 Rule 11D application have been called in question. It was a suit for partition. But there was a latest judgment, a coordinate bench of this honorable court have held that execution of a sale deed, the limitation starts from the date of execution of the sale deed as against a co-parsoner. So therefore it is 2004 the sale deed which is called in question.
Petitioner, release this matter on when do you want?
Well, any day in 22nd, 16th.
22nd of April.
Much obliged.
Yes.
35. Narayan Bhatem.
Lord, in this matter, my lord,
short accommodation, my lord.
wakalat for respondent number 1 and 3 yesterday,
Ah,
and respondent number 2's wakalat I am awaiting. Lord, I want to produce, my lord, judgment which was sought for execution in execution petition. My lord, next week, any date, my lord. It's a very short question, my lord.
at the request of learned counsel for respondent number 1 to 3, release this matter.
Next week, my lord, any date, my lord.
You want it on 17th?
Yes, my lord, 17th is fine.
17th.
Obliged.
Number 36, V.B. Shivkumar.
In a suit for partition,
Ah,
an application was filed by the petitioner who was a purchaser seeking dismissal of the suit under 7 Rule 11. The learned judge rejected the application as against which I am in this revision petition.
yes. Where is the plaint?
The plaint is at page 42. Page 42. My lords may turn to paragraph 5, my lord, at page 45.
Suit for partition.
Suit for partition.
Ah,
And she claims that she has a right in the property. And so far as that aspect of the matter was, that is Siddhamma by her legal representatives. We were purchasers of the property and we are in possession of the property. Now turn to para 5 minute. It is submitted that during some misunderstanding,
for a subsequent purchaser.
I am a purchaser in 2013 and 14.
And no challenge is raised to the sale date.
No, my lord. Even the prayer,
prayer illa.
Illa. Questioning my legality of purchase of the property is also
In the
not
body of the plaint, they have said about the sale date.
They have not set up with regard to sale deal.
Ah,
But they say that we are strangers and we are not family members. That is what they say, my lord. Kindly see para 5, my lord.
ah.
It is submitted that due to some misunderstanding in the family, plaintiff has demanded to effect division and allot her separate share in the suit property. At the instance of defendant 2 and 3, agreed to give allot share, but thereafter they postpone the same by one or other reason. Thereafter, first defendant in collusion with defendant 2 to 4 filed a suit for relief of partition by suppressing relationship by not including plaintiff in the said suit on the file of the principal JMFC in 251 of 2014. Immediately after knowing the said fact, she voluntarily filed an application for impleading, as she is one of the necessary party to the said suit. When the said application is pending consideration, defendants 1 to 5 colluded with each other without noticing the plaintiff. They withdrew the said suit as not pressed, only to receive the right of the plaintiff. Hence, without alternative, she has filed the present suit for partition, is what she says. But I am a stranger. I am a purchaser of the property. I am the fifth defendant in the said case. And she categorically says that defendants 5 and 6 are not family members. Kindly go to para 3 minute. Only insofar as defendants 1, 2 and 3, there is a relief sought for. Fifth defendant is a stranger to the joint family. Plaintiff and defendants 1 to 4 are legal heirs of deceased Siddhappa. Now, my sale deeds are not questioned before the court because nothing is stated insofar as these aspects of the matter is concerned. And a contention is raised that defendant 5 is trying to alienate the suit property. The last sentence in para 6 minute, it is submitted to make selfish gains, ignoring the right of plaintiff, suit property by collusion with defendant 2 to 4, by concocting certain records of the suit property. Defendant 5 changed the khata with collusion with revenue authorities. If any documents standing in defendant's name, those documents are not binding on the plaintiff, since plaintiff is not party to the said document. Now, based on khata, defendant 5 is trying to alienate the property. But looks as if it's a speculative litigation that is raised by them. And insofar as my right is concerned, I have stated in my written statement that I am a purchaser of the property. I filed my written statement in the trial.
Issue notice to response number 1 to 4. You are filing a memo regarding the other.
Yes, I'll file it.
Learned counsel for the petitioner has filed a memo seeking dispensation of notice to response number 5 to 11 on the ground that 5 to.
No relief is sought against.
5 to 21 on the ground that the said respondents are co-defendants along with the petitioner herein in the suit, and no relief is claimed against them in this CRP. Full stop. Next para, at the risk of the petitioner, notice to response number so and so is dispensed with. Full stop. Next para, learned counsel for petitioner submits, comma, while taking this court through the plaint in OS number 153 of 2015, that in paragraph number 3, it is clearly stated that fifth respondent is a stranger to the joint family. And in paragraph number 6, it is stated that the fifth respondent got the khata changed in his name in the revenue records. Full stop. No relief is claimed against dependent number 5.
Yes.
Full stop. The sale deed executed by the other defendants in favor of
plaintiff,
the fifth defendant, has not been questioned in the suit, and therefore the fifth defendant filed an application under Order 7 Rule 11 seeking rejection of the plaint, as there is no cause of action for the suit, and a stand has been clearly taken by the fifth respondent that the other defendants have sold the property in favor of the fifth defendant under registered sale deed dated.
The registered sale deed under which the petitioner purchases the property said so, madam. Sorry. That is on 18/12/85, my lord.
18/12/85. 1985.
85.
Full stop. Next para. Matter requires consideration. Full stop. Accordingly, there shall be an ad interim order of stay of the impugned order at Annexure A and all further proceedings in OS number 153 of 2015 on the file of the learned principal, civil judge and JMFC, Dodbalapura till the next date of it.
37, U. Chandramouli.
Matter is called out. There is no representation for the petitioner. Release this matter on 25th of April.
38, Shravan Eslopre.
Yes, I had third copy. My learned friend is
Copy
up
could
here.
here. I have also received, my lord, the wakalat. Only along with the GPA, I'll have to file the wakalat. I request a week's accommodation. I'll file it and matter can be taken up next week, my lord. I have also informed learned senior counsel. There's no objection.
He has informed.
At the request of learned counsel for
Respondent.
Respondent Shri
Vivek BN for Abhinavar. Vivek BN.
Shri Vivek BN.
Please.
14th.
Come on, release this matter.
Simrat, the trial court is on 15th.
21st. 21st or 22nd.
Let him not precipitate the marking of marking of documents, Xerox copies. That is the.
ನೀವು object ಮಾಡಿ ಅಲ್ಲಿ.
That may be observed, man.
No. That no court need to give any such right. As a matter of right, you can object if any such documents are sought to be marked.
No, all I want to show is
22nd, 23rd, any day.
22nd of
17th ಇದೆ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 15th ಹಾಕೊಂಡ್ರೆ ಅದು ಅವತ್ತು ಮುಗಿಸ್ಬಿಡೋಣ.
15 ಬೇಡ 22nd ಇರಲಿ
17 ಇದೆ ಅಂತ
17 ಇದೆಯಾ?
my lord.
ಹಂಗಾರೆ 16th of April.
Much of
16 there is some inconvenience.
ಅಲ್ಲ ಮುಗಿಸ್ಬಿಡೋಣ, one short point involved.
Yes.
Serial number 39. HN Basuraju, RP.
I'm seeking leave your lordships to file a compilation of documents, my lord, instead of taking your lordships to one writ petition or the other. May I permit me, my lord, to pass on that compendium documents. Just look at your lordship's order, my lord, where seeking the review. Just may kindly go to page 2, page 4, ink page 16, paragraph 2 of your lordship's order. May I read it, my lord? Page 16 of my review petition, paragraph 2, my lord, your lordship's order, which is the order I am seeking review.
Paragraph?
Para 2.
Para 2 of the order.
Yes, para 2 of the order. The petitioner herein filed WP number so and so, contending that even as per the document submitted by the fifth respondent, it was clear that as on the date when the application was filed, no elections are held to the managing committee of fifth respondent society. Therefore, having regard to the relevant provisions contained in the fishing rights, the application filed by the fifth respondent should have been rejected. This court by order dated so and so held that reading of the conditions in fishing policy makes it clear that application which did not accompany the document substantiating the constitution of the board, its meeting election, was liable to be rejected. Stop it for a moment, my lord. May kindly have the compendium which I have placed on record for a moment now. Lord, the board of directors meeting, copy of that meeting, Lord, produced. 38 general body. Where is the general body? Page 42 may kindly be seen, my lord. This is in manuscript, my lord. If it's not legible, I can place the typed copy. But time, I think it is readable. Otherwise, I can place it on record a typed copy. This was the meeting of the managing committee dated 25/2022, KV Jairam, in which, my lord, subject number is 4, my lord, at the bottom. ತುಮಕೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿಯಲ್ಲಿ ಮಲ್ಲಸಂದ್ರ ಕೆರೆಯ ಪಾಶುವಾರು ಹಕ್ಕು ಪಡೆಯುವ ವಿಚಾರ, ಸಂಘದ ಸದಸ್ಯರಿಗೆ ಅನುಕೂಲ ಕಲ್ಪಿಸಿಕೊಡುವ ಸಂಬಂಧ ಕಸಬಾ ಹೋಬಳಿ ಮಲ್ಲಸಂದ್ರ ಕೆರೆ ಮೀನುಗಾರಿಕೆ ನಡೆಸಲು 22ರಿಂದ ಮುಂದಿನ 5 ವರ್ಷಗಳವರೆಗೆ ಮೀನು ಕೃಷಿ ನಡೆಸಲು ಪಾಶುವಾರು ಹಕ್ಕು ಪಡೆಯಲು ಸರ್ಕಾರ ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆಯ ಪಾವತಿ ಮಾಡಿ ಪಾಶುವಾರು ಹಕ್ಕನ್ನು ಪಡೆಯಲು ಪೂರ್ಣ ಅಧಿಕಾರವನ್ನು ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಯವರಿಗೆ ನೀಡಲಾಗಿದೆ. This is the resolution passed. My lord, this resolution is also admitted by the authorities in their report. Your lordship may kindly go to page 60 of the very same compilation. Page 60. It's a recommendation by the assistant joint directors to director making favor to grant of floods in my favor. 7/9/2022. May kindly go to page 61, madam. There are columns are there, madam. There are 4 columns. Could you last table?
Yes.
My lord, the first column, what are the documents filed by each society is explained. And second, third column is relating to the petitioner society. Another is respondent society. There's a reference about the 7, my lord, item number 7. ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆ ನಡವಳಿಕೆಗಳು ಲಗತ್ತಿಸಿದೆ. Our Lagatsi, that there is no dispute. The managing committee resolution is there. My lord, absolutely. Amen. Therefore, my lord, the first question, where managing committee was not there and no resolution was produced, that appears to be incorrect on the record, my lord. I wanted to get it correct.
The information that was sought was regarding the elections.
Yes, not elections. Not election. I will tell, my lord. 2016, up to 2016, the society was in the hands of the liquidator. A revival order was passed in 2016. Thereafter, election have taken place in 2016. In 2021, term expires. Thereafter, my lord, government extended the term because of the code. Your lordship may kindly see the circulars I have produced. It is a statutory circular issued by the government, my lord. Your lordships will get a circular. Page 32, my lord. 26/4/2020.
I have dealt with all those matters.
Your lordships.
I have dealt with those matters.
Yes.
When I was sitting in that roster, cooperative, I have dealt with those matters.
Correct.
I know, yes.
Now, circular was issued.
Yes.
It where the term of the office bearer those who were elected.
Yes.
Despite after expiry, they are continued. My lord, this circular was further clarified. Page 35, my lord. Next circular is 21/2022. On that, my lord, the authorities and societies election authority instructed to take necessary steps to conduct the election. For the purpose of conducting the election, first time by virtue of an order of the concerned registrar, an administrator was appointed on 31/5/2022. My lord, 35/2022 and anterior to 35/2022, there was a board of directors. They were there. They were passed a resolution and audited accounts have been provided fully in consonance with the requirement to be provided under clause 4 of the policy of the fishing. Therefore, first part of the orders, where my lord, it requires reconsideration according to me is, there is a compliance of clause 4 of the government order. Therefore, this election, elected body was there. Elected body only passed a resolution. Then, my lord, after the election, by that time lease was granted to us. That election process and result. My lord, your lordship may kindly see when the election was held. Copy we have produced. Your lordship may kindly go to page 31 of the compendium. Our election was held on 15/8/2016.
Now you please read paragraph number 16 of my order.
Paragraph
16 of my order.
Yes. This court is of the considered opinion that having regard to the findings rendered by the Director of Fisheries regarding eligibility of the fifth respondent, in as much as holding the elections and furnishing of the audited statement of accounts for a minimum period of 3 years, both societies are permitted to furnish all relevant information that would meet the requirements of fishing policy. It may be a case where right of the fishing will have to be actioned in terms of the provisions of fishing policy. Now, my lord, the first point I have clarified by virtue of this review and compilation. Elections were there.
That you will have to go and place before the authority. That is what I have
That is
directed.
the reason the lordship may kindly see the report. That audited account were also there.
I have asked you to place it before the
Not
authority.
now.
Let him take a decision.
When the fresh decision was taken at the after responding to the invitation of applications by the fishing societies, these documents are very much there. A second and a doubling exercise may not be warranting is my submission. That precisely the point I wanted to raise in the review petition. Could your lordship may kindly look at, my lord, the document which I am referring to, page that is, my lord, the report submitted on page 60, my lord. Page 60, which I read to your lordships in so far as compliance of election and other things. Page 60 may kindly be seen.
Yes.
Again, I would like to take your lordships to the table. Then, my lord, what are the documents is produced? Prescribed form in form number 9, number 1. Then resolution, notarize it. Then register certificate of the society.
We are only concerned with those two documents.
Yes. Now,
one
two documents
regarding election.
No.
Another one
Adilita Mandal is
regarding
available.
the audited.
All these documents are produced. ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆ ನಡವಳಿಕೆಗಳು ಕೊಟ್ಟಿದ್ದೀವಿ. 3 ವರ್ಷಕ್ಕೆ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿ is also there. 7 and 8. Both documents are very much available to the authorities on the date when the decision was taken at the first instance. By virtue of your lordship's order, the authorities were called upon to re-examine the matter. According to me, it may not be necessary. That's only the submission, my lord, I wanted to make in this review petition. Then, my lord, if your lordship's not agreeing with that, my submissions, my lord, the time is granted by your lordships 2 weeks to take a decision. That time may kindly be enlarged by another 2 weeks. With great respect, I am making that request. First part of your lordships is complied with because time schedule is there.
Allala, you were permitted to furnish.
We have filed that. On protest, subject to result of the
Let
review.
him take a decision then.
Very, very well. That's the reason. Therefore, decision taking process now at the hands of the director, your lordship stipulated that time. That time may kindly be enlarged by another 2 weeks is my request. Because I can take the matter in appeal I wanted to if my client advises. I am going to lose a valuable right if it is not denied. If it takes a first decision, it gives a new cause for me to challenge. That's the reason I am asking, not otherwise. Even I wanted to get it corrected by exercise of your lordship review jurisdiction. Anyhow, I could not able to convince. Anyhow, my lord, I can take a chance. It is my submission. Kindly enlarge that time by another 2 weeks from today, my lord. That is my request.
Barkar. Learned Senior Counsel Shri M.R. Rajagopal, appearing for the review petitioner, who was respondent number 5 in the writ petition, submits while filing a memo along with certain documents, that copy of the resolution dated 25/2022 passed by the
Next election, yavaga.
managing committee of the society has been placed along with the application seeking fishing rights. Full stop. The same has been considered by the fourth respondent, deputy director or assistant director.
Page 61. That is joint director's office. 7/9/2022 recommendation.
By the competent authority of the fisheries department. Full stop. Learned Senior Counsel submits that there was no need for this court to have remanded the matter back to the Director of Fisheries for the purpose of enabling the rival societies to furnish all relevant information, more particularly the information regarding the elections held to the society, which is the requirement in terms of the law and the form prescribed for considering such applications. Full stop. Next para. In the considered opinion of this court, this is precisely the information that is sought to be permitted to be placed before the Director of Fisheries in terms of paragraph number 16 of the order passed by this court. Full stop. If such information is placed by the petitioner, comma, the same will be considered in terms of the directions issued by this court. Full stop. No error apparent on the face of the record is pointed out by the learned senior counsel appearing for the review petitioner. Full stop. Next para. Accordingly, the review petition stands rejected. Full stop. At this juncture, learned senior counsel submits that the petitioner has furnished all the documents within the time stipulated in the order passed by this court. Full stop. However, the Director of Fisheries has not passed any orders till date, and therefore it is prayed that the period of 4 weeks granted by this court may be further extended by another period of 2 weeks. Full stop. Next para. If the Director of Fisheries has not passed an order within a period of 4 weeks from the date when which the documents are tendered by both the parties, both the societies, comma, the Director of Fisheries is permitted to pass such an order as expeditiously as possible. Ordered accordingly.
Within 2 weeks, your lordships make it clear.
Huh?
Expeditiously and 2 weeks.
Order pass ಮಾಡೋದಕ್ಕೆ.
ಅದಕ್ಕೆ 2 weeks time kindly.
Yes.
Hearing interlocutory application, serial number 40. Abhinav Ramana.
I appeal for the
Respondent. But I am appealing for petitioner. My lord, there is a delay of 4 days in preferring the present petition.
Yes.
My lord, the suit is filed for partition. My lord, the petitioners herein, my lord, were arrayed as defendant number 2, 6, 7, 8, and 8, 9, and 16. My lord, earlier, my lord, we filed an application seeking rejection of plaint. My lord, under the provisions of Order 7, Rule 11A, stating that, my lord, there is no cause of action for filing the suit. That application, my lord, came to be rejected by the trial court, holding that, my lord, there is a cause of action. Our contention, my lord, basically was there are totally 23 items of the suit schedule properties. All the items of the suit schedule properties are my self-acquired properties, having purchased the same under various registered sale deeds. My lord, along with the application, my lord, I had produced as many as 23 sale deeds and sought for rejection of the plaint. That application, my lord, came to be rejected. Subsequently, my lord, I have filed one more application, my lord, which is numbered as IA number 10. My lord, here, my lord, I have invoked the provisions of Order 7, Rule 11B and D. My lord, stating that the relief is undervalued and, my lord, the suit is barred by limitation. My lord, this application, my lord, is rejected, my lord, which is impugned in the presented petition, holding that, my lord, the second application, my lord, amounts to res judicata. My lord, this is what the trial court has held. My lord, my respectful submission, my lord, is that firstly, my lord, the provision invoked is entirely different. And, my lord, the grounds urged from the first application to the subsequent application, my lord, are entirely different. So my respectful submission is the question of, my lord, the applicability of res judicata, my lord, insofar as these two applications are concerned, my lord, will not be proper. My lord, kindly see, my lord, the impugned order. My lords will kindly get the impugned order at page
Page 13.
Page 13, my lord.
Yes.
Kindly see the reasoning, my lord.
Hmm.
Page 14.
Hmm.
Both sides have filed citations in support of their respective contentions and claim.
Hmm.
The citations are not considered in view of application is hit by principles of res judicata as interim application number 7 filed under order 7 rule 11A of CPC dated 20/2/2021. Though said application in respect of plaint does not disclose cause of action. And please see, my lord, page 15. Keeping in mind, while this court deciding the said application, under first application, considered not only cause of action, even also law of limitation. Because the cause of action means something, my lord, this is what has been extracted. My lord, there, my lord, the court did not have an occasion to, my lord, get into the aspect of limitation at all. My lord, in order to consider whether the suit is hit by provisions of, my lord, the Limitation Act, the court will have to get into which article of Limitation Act is applicable, what is the starting point of limitation, my lord, whether the list is filed in time. My lord, all those aspects were never considered in the previous application. What was considered, my lord, in the previous application is, my lord, since, my lord, the plaint discloses a cause of action, my lord, since it is a suit for partition, that application came to be rejected. But here, my lord, please see, my lord, the plaint. Now, this is the only reasoning, my lord, in the impugned order. One, my lord, the trial court says it is hit by res judicata. Second, my lord, in the earlier application itself, I have considered the question of limitation in the application for cause of action. So, therefore, the present application wherein I have invoked that the suit is barred by limitation will not survive. And it's only a 2 paragraphs order, my lord. Now, please see the plaint, my lord. It is at page number 18. My lord, the relationship between the parties is not in dispute. And, my lord, the fact that, my lord, the defendant 10 to, my lord, the 16 are the purchasers are also not in dispute between the parties. Now, your lordship may kindly take the prayer para, which is at page number 26. My lord,
can you go on filing applications after applications?
My lord, yes,
by saying, no, earlier I had invoked only 11 rule A.
Please, my lord.
Now I am going to invoke 11 rule D.
If law permits, yes, please, my lord. My lord,
can do it.
Yes, please, my lord. That is the
order 2, rule 2 will not come into the picture.
That is, my lord, with respect to
same thing, same principle.
With respect to suits,
if you have an opportunity to raise an issue, you should raise it fully.
My lord,
how can you raise these questions piecemeal?
My lord, what happened, transpired is, my lord, earlier.
Anyway, 11 rule B will not apply in this case.
Yes.
Please read B.
My lord, where the suit, my lord, is underway.
Court has to pass an order, and
Please
if I do not pay the court fee,
what the
then
provision says.
Yes, please.
Unless that issue is raised, the court directs the plaintiff to
calling upon him to make
and the plaintiff fails to do.
So.
Only then the question will arise.
Please, ma'am.
You can't invoke the provision to issue a direction. Let the plaintiff pay the value the suit properly. Thereafter, let him pay. You issue directions. Not possible. 11B will definitely not apply.
11
insofar as the D is concerned.
Please,
this is the answer.
Yes.
You cannot raise the issue piecemeal. You had an opportunity to say so in the earlier application, and though you did not raise that contention, the court says we have answered it in the order,
which is factually incorrect, my lord, because that though the aspect of limitation was never dealt by the court at all. Now, my lord, as my lords are aware, my lord, the plaint has to be rejected by going through the averments made in the plaint. Now, please see, my lord, page 27.
Before that, you will have to answer this question,
please,
as to how a subsequent application is maintainable. It is only on that ground this application is rejected.
Yes, please, my lord.
Please tell what is wrong in the order.
My lord, the judgment, my lord, readily not. I don't have a hard copy.
But even otherwise, my lord,
I'll place it on record.
The limitation is a mixed question of law and fact.
That's all right.
And there is
Lord,
a 9.
As my lords are posing a question, whether subsequent application by invoking a different provision, my lord, state on the point, my lord, I'll place it on record, my lord.
Because that is the only ground on which the application has been rejected.
Yes, please. I'll just place it on record. Other point, I'll place it on record.
See, what is the ground that you have raised?
My lord, here, my lord, 7 rule B, my lord.
What is the ground?
Alla,
Say,
before, before my lord,
same
Erila, no
Alla,
grounds.
please see page 27, the plaint itself.
Allappa, what is the grounds that you have raised now?
My lord, all these are, my
What
lord,
is wrong in the order? What have you stated?
my lord, that my lord, firstly, my lord, the principles of res judicata, my lord, will not apply to the case on hand. For the reason, my lord, a different provision is invoked and the grounds are entirely different. In the subsequent application,
Means you would have been ready with the decision.
Yes.
To support your contention.
Howda.
And now you are saying, no, please give me some time.
Research
ಅಲ್ಲ,
ಮಾಡಿದ್ದೀನಿ.
earlier
On this
affidavit
point,
ನಲ್ಲೂ same averments.
another, my lord,
ಇದರಲ್ಲೂ same averments.
another aspect, my lord. All these, my lord, if my lords were to kindly take page 27 for a moment, please see, my lord, the prayer, plaint itself, from the plaint averment itself. Prayer B, to declare the sale deed executed by defendants 2, 7 to 9.
So that is what I am saying. It was available for you. You didn't raise that issue. So therefore, order 2, rule 2 also will come into the picture now.
Exactly.
Order 2, rule 2, perhaps, my lord, in my
Why not?
submission, that is applicable
Same
to, my lord.
principles.
Where,
Yes,
my lord?
abundant-
Same principles.
abundant
When you
area.
had an opportunity to raise an issue, you did not do so, which means you have given up.
My lord, come up with some citation. My lords may kindly have this on 22nd or 23rd. I'll place it on record, my lord. This is something different, my lord. This is
ಅಲ್ಲ,
perhaps this kind of.
All this, the law laid down by the Supreme Court, having regard to the provisions, is with this wisdom that you will not permit a party to go on filing applications or applications trying to drag on the proceedings.
Yes.
That is the wisdom behind this.
That amounts to be abuse, my lord. The Supreme Court has said that amounts to abuse. And limitation also will not come because it is within 12 years.
My lord, and I'll get back. My lords may have this on 22nd, 23rd, my lord. By then, we'll come back, my lord, with some support.
There is nothing else to be considered, my lord. It's crystal clear.
Heard the learned counsel for the petitioner and learned counsel for the respondent for some time.
Till such time, some protection, my lord, the matter before the trial court is proceeding.
What is this? I am ready to dismiss the CRP now, and you are asking for time. Nevertheless, at the request of learned counsel for petitioner, who seeks to place reliance on some decisions, release this matter on 17th of April.
17th, 22nd, my lord, please. There is some inconvenience.
22nd of April.
Please.
For further hearing.
Please.
Yes.
Right.
Serial number 41.
My lord,
A. Karambaya, getting
my
the
lord,
model.
it is held up in a.
My lord, there is a law and order issue, my lord. It's a pre-metric hostile issue in Mysore. Already, this is a 7th or 8th adjournment, my lord. It's been
No, she is asking for a passover, not adjournment.
Oh, sorry.
Passover ಮಾಡಬಹುದಾ?
ಮಾಡಿ.
Passover.
DP Mahesh. DP Mahesh.
Appear for the petitioner.
Yes.
I have sought for amendment, my lord, in view of the subsequent development, prayer number A, seeking quashing of the allotment letter in favor of respondent number 2 is now inconsequential because after interim order dated 26/2020, application prayer A, the BD has executed sale deed in favor of respondent number 2, who in turn sold in favor of third party, my lord. Therefore, I have filed contempt petition. In the contempt petition, my lord, instead of item number 1 of the schedule, is another property is reserved in the contempt. That is why I have sought for the amendment of the property to be included in the schedule. Now, in view of that, my lord, a memo is also filed to dispense with the notice to R2. That is already allowed by this honorable court on the last date of hearing. Now, in so far as prayer number 2 and 3, my lord, directing the respondent to consider the case of the petitioner for allotment of the sites to some extent for use of land without acquisition for the RME extension.
May make a request, but we'll consider it in accordance with law within a period, time-bound period. Lordship may direct us to complete it, Lord, within 2 months period. We'll take note of the entire extent of the land utilized and whether it was a part of the acquired area, what is the unacquired area we have utilized. All that measurement survey, everything has to be conducted. We will do that, complete it. Whatever, if we have to allot, we'll allot it to him in accordance with law within a period of 2 months. Otherwise, what happens is all this issue with regard to the extent of the land, Lord, how much has to be allotted. Your Lordships have held that in 2018 there is a circular. Not all these things. Your Lordships have directed the BDA to consider, act in accordance with the circular. Lord, these are all things are there. Lord, we'll take it. We'll give a logical end to this, Lord, within 2 months.
Then we will record your statement. We'll keep the writ petition pending. We'll permit you to consider the grievance of the petitioner. You please do it and place it before the court.
Yes, no. Yes.
Huh?
Yes. Lordship may otherwise dispose it of for compliance. Your Lordship may give it after 2 months.
Better.
Please.
What do you say?
Yes.
Huh?
Yes.
We will keep it pending.
It can be disposed of also.
Can be disposed
Yes.
of. I work.
For record purpose, application for amendment may kindly be allowed.
ಏನು ಅಮೆಂಡ್ಮೆಂಟ್ ಏನು
ಶೆಡ್ಯೂಲ್ ನಂಬರ್
ನಾನು ಇದರಲ್ಲಿ ಹೇಳ್ಬಿಡ್ತೀನಿ say so in the order. Your contention is that your lands have been used
without
by BDA without acquisition.
Yes.
And you
have requested BDA to, as per the circular available in accordance with law, allot the developed land in the subsequent layout. RME extension is acquired 77 alli. Subsequent HSR layout to BTM alli avare resolution pass madidru. That can be considered the development is not, earlier it was 50%, later it is reduced to 27%. So accordance with law, whatever is available and applicable to the petitioner, it can be considered.
So what has happened is from RMV they have gone and given it in HSR. Not
RMV 77.
Rule ಇದು ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇದು ರೂಲ್ 11 ವೈಲೇಷನ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ Lordship may say in accordance with law, Lord.
That is what he is also.
Yes,
accordance
please.
with law.
In accordance.
Please.
The grievance of the petitioners is that although the respondent, first respondent BDA,
only sole respondent,
has utilized
$37 guntas. In survey number 1/1.
37 guntas of land. In survey number
1/1.
1/1
and 44.
And 44 of Rajmahal, Chikkamarenahಳ್ಳಿ village, Kasba Hobli, without acquisition.
Yes.
And the petitioners have given representations to the BDA for allotment of
the
developed sites.
Yes.
In accordance with law, nevertheless, the same has not been considered by the first respondent BDA.
As per annexure page number 74, so item number 2 of schedule is already allotted. Allotment letter is issued, partially implemented. Annexure page number 74. Item number 2 of the schedule to the writ petition. Allotment letter is issued by collecting the additional number.
ಆಮೇಲೆ
ಅದು ಒಂದೇ ಆಗಿರೋದು, ರಿಮೈನಿಂಗ್ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಕೇಳಿ.
Learned counsel for the petitioner, however, submits that at annexure L is an allotment letter dated 24/2016
In respect of item number 2 of the
where site number 410 of JP Nagar 4th phase
yes,
has been allotted to the petitioner, but that only fulfills a part of the obligation on the part of the BDA, and it is yet to
execute sale.
allot the legitimate extent of land to the petitioner. Full stop. During the course of these proceedings, interim directions were issued by this court
26 to 2020.
On 26/2/2020, directing the respondent BDA not to proceed further in the matter of item number 1 of the petition schedule property, that is site number 626 par C, HSR 6th sector, Bangalore, until further orders. Full stop. However, the first respondent executed
As regard to item number 2 to 5, not to precipitate it. Second portion of the order. As regard to
it was also directed that insofar as items number 2 to 5 are concerned, the BDA shall not create any third party rights during the pendency of the petition. Full stop. However, in violation of the interim directions given by this court, a sale deed dated 3/3/2020 was executed by BDA in favor of respondent number 2.
Yes. In respect of item number 1 only.
In respect of item number 1. Full stop. The petitioner was constrained to file a contempt petition in CCC number 302 of 2021. Full stop. Respondent number 1 filed an affidavit before the Honorable Division Bench that a suit in OS number 4455 of 2021 has been filed for cancellation of the sale deed. Full stop. The Division Bench, by order dated 24/4/2024, directed the BDA to reserve site number 1369 situated at Saram Vishweshwaraya further extension layout in favor of the petitioner in lieu of item number 1 of the petition schedule property. Full stop. The contempt petition was disposed of by making the interim order dated 24/4/2024 absolute. Full stop. In that view of the matter, next para, an impleading amendment application has been filed in IA number 1 of 2024 to include site number 1369 situated at Saram Vishweshwaraya further extension layout in lieu of item number 1.
Yes.
Full stop. Next para. Learned counsel for the first respondent BDA submits on instructions that the grievance of the petitioner will be considered in accordance with law and action will be taken to allot the sites in favor of the petitioner in accordance with law. Full stop. The learned counsel would therefore pray that the writ petition may be accordingly disposed of with the direction to the first respondent. Full stop. Next para. Learned counsel for the petitioner also submits on instructions that the petition may be disposed of with such directions. Full stop. Next para. Accordingly, the writ petition stands disposed of with a direction to the first respondent, Bangalore Development Authority, to proceed to consider the request made by the petitioner for allotment of developed sites in accordance with law and having regard to the directions issued by the division bench.
And also interim order passed by this son.
In respect of site number 1369 situated at Saram Vishweshwaraya further extension layout.
Yes.
Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months.
2 months.
From the date of receipt of a copy of this order. Please. Ordered accordingly.
Interim order till then, not to create any third party interest in respect of 2 to
Absolute.
that has been made absolute by the division bench itself.
ಅಲ್ಲ ಒಂದಕ್ಕೆ ಅಷ್ಟೇನೆ ತಮ್ಮ ಆರ್ಡರ್ 2 to 5 ಇದೆ 20 ತಮ್ಮ ಆರ್ಡರ್ 26/2 ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 2 to 5
ಸೇರಿಸ್ಕೊಂಬಿಡಿ ಅನ್ಕೊಳ್ಳಿ
26 to 2020 ನಲ್ಲಿ
the interim directions issued by this court insofar as items number 2 to 5 shall continue till a decision is taken by the first respondent. Yes.
One request, Lordship said on instruction, Lord, we'll take action to allot site. We'll take action, we'll take a decision to allot sites.
Adene.
Mele.
In accordance with law ಅಂತ ಹೇಳಿದೀನಿ. What does it mean? Yes.
Please.
Serial number 43, Hanumantraya D.
This matter, 2010 acquisition, last week Lordship were given a time to hear the main matter itself, my lord. Hear the main matter itself because 2010 acquisition we have taken time and
yes.
Earlier writ petition was filed, my lord. This court remanded the matter to the SLO to after hearing both the parties. Annexure H is the order, my lord. It is the only reason. A detailed order was passed by the land acquisition officer after hearing the other side and taking the report from the DO also, my lord. It is required for formation of the road. I have given that earlier map also. Annexure H, my lord.
ಏನು interim orders ಏನು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
Interim order. Interim order.
Interim order.
ಅಲ್ಲ dispose of ಮಾಡ್ತೀನಿ ಅಂತ. Interim order. Disposal 2020 matter ಅದಕ್ಕಾಗಿ
Annexure H.
ಹೌದು.
ಏನದು? Page number?
Page number, my lord. This is 174, my lord. Page 175, my lord, operative portion of the. ಪ್ರತಿವಾದಿ ಶ್ರೀಮತಿ ಥರ್ಡ್ ಪ್ಯಾರಾ, my lord. ಪ್ರತಿವಾದಿ ಶ್ರೀಮತಿ ಪದ್ಮಾ ಕುಮ್ನಾಡ್ ಅವರಿಗೆ ಕಚೇರಿಯಿಂದ 19/9/2021 ತಿಳುವಳಿಕೆ ನೋಟಿಸ್ ನೀಡಿ 20/19 ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆಗೆ ಹಾಜರಾಗಲು ಸೂಚಿಸಿ 26/9/19 ವಿಚಾರಣೆ ಮಾಡಿದೆ. ಅರ್ಜಿದಾರ ಶ್ರೀಮತಿ ಚಂದ್ರಶೇಖರ್ ಅವರು ಹಾಜರಾಗಿ ಸದರಿ ಜಮೀನಲ್ಲಿ ಗೋಡಂಬಿ ಮಾವು ಇದ್ದು ಇದುವರೆಗೂ ಭೂಪರ ಯಾರ ಪರಿಹಾರವಿಲ್ಲ. ಈ ಜಮೀನು ಜೀವನಾಧಾರಕ್ಕೆ ಇದ್ದು ಬೇರೆ ಯಾವುದೇ ಆದಾಯದ ಮೂಲ ಇರುವುದಿಲ್ಲ. ಆದುದರಿಂದ ಭೂಸ್ವಾಧೀನದಿಂದ ಕೈ ಬಿಡಲು ಕೋರಿದರು. ಅದರಂತೆ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳವರ ವರದಿ ಪಡೆಯಲು ಸೂಚಿಸಿ ವಿಚಾರಣೆ ಮುಕ್ತಾಯಗೊಳಿಸಲಾಯಿತು. ಸದರಿ ಅರ್ಜಿಯ ಕೋರಿಕೆಗಾಗಿ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯವನ್ನು ನೀಡಲು ಈ ಕಚೇರಿಯ ಪತ್ರ ದಿನಾಂಕ 19/9/2010 ಅಂತ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು 2 KIDB ಅವರನ್ನು ಕೇಳಲಾಗಿತ್ತು. ಅವರು 18/19 ಪತ್ರದಲ್ಲಿ ವರದಿ ನೀಡಿ ಪ್ರಶ್ನಿತ ಸರ್ವೆ ನಂಬರ್ 146 ಜಮೀನಿನಲ್ಲಿ ಮಸ್ತೇನಹಳ್ಳಿ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶದ ಮುಖ್ಯ ರಸ್ತೆ ಮಾಡಲು ಅವಶ್ಯಕವಾಗಿ ಬೇಕಾಗಿದೆ. ಈ ಸರ್ವೆ ನಂಬರ್ ಮುಖಾಂತರ ಮಸ್ತೇನಹಳ್ಳಿಯಿಂದ ಕೈವಾರ ಗ್ರಾಮಕ್ಕೆ ಹೋಗುವ ರಸ್ತೆ ಹಾದು ಹೋಗುತ್ತಿದ್ದು ಈ ರಸ್ತೆಯನ್ನು ಮಂಡಳಿಯಿಂದ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಲಾಗುತ್ತಿದೆ. ಮೇಲ್ಕಂಡ ಜಮೀನು ರಸ್ತೆಗೆ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ ಎಂದು ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತಾರೆ. ಈ ಹಿಂದೆ ವಿಧಿ 28(3) ವಿಚಾರಣೆಯಲ್ಲಿ ಸಹ ಈ ಜಮೀನು ಸೇರಿದಂತೆ ಈ ಗ್ರಾಮದ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಅಧಿಸೂಚಿತವಾದ ಇತರೆ ಜಮೀನುಗಳು ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಕ್ಕೆ
ಅವಶ್ಯವಾಗಿ ಬೇಕಾಗಿರುವುದನ್ನು ನಿರ್ಧರಿಸಲಾಗಿದೆ. ದಿನಾಂಕ 16/1/2019 ಸದರಿ ಜಮೀನಿನ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿರುತ್ತದೆ. ಸದರಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ
Because it is essential for formation of the road, you cannot
already
drop it.
yes, my lord. We have given a map also. That is
That's why I said there is no interim order.
yeah, interim order illa.
You would have proceeded.
Yes.
ಏನಾಗಿದೆ? What is the difficulty?
Alla, because since matter is pending, my lord.
Yes.
My lordship, kindly have it on Tuesday.
Huh?
Kindly have it on Tuesday, your lordship.
Tuesday.
Your lordship.
Finally, at the request of learned counsel for petitioner, release this matter on 15th of April. Huh? Yes.
Interim order is there, your lordship.
Interim, ellide?
Lordship, last time it was not extended, but interim order is there, yours.
Interim order granted earlier stands extended till the next date of hearing.
Lordship.
44. May I request
To accommodate 3 days time up to 15th or 16th, my lord, this matter. I requested my learned friend.
At the request of learned counsel for petitioner, release this matter on?
You want it on 17th.
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 17th of April.
Interim order may find it.
Interim order granted earlier stands extended till the next date of hearing.
45. Sampath A. Sitting stay. 45.
For the I have been impleaded, my lords, insofar as I am the respondent 7 to 8, my lord, 7.
This is only, my lord, there is some, by mistakenly second notification was issued. The land was already acquired and the compensation was received by the petitioner. Subsequent for widening of the road, my lord, by mistake they issued one more notification. After my lord, they issuing the final notification, when survey was conducted, we came to know that it is already in the acquired area. That mistake was taken benefit of that, my lord, this petition was filed.
ಏನಂತ?
Acquisition ಗೆ compensation ಕೊಡಿ ಅಂತ second notification.
They have taken compensation.
Already taken. I produced the documents also. That is admitted fact also. They have received the compensation, including the other benefit also, shifting of the business.
Matter is called out. There is no representation for the petitioner. Release this matter on 15th of April.
16th, my lords.
16th.
Yes, my lord.
All right.
Serial number 46. Arjun, serial number 47. Venugopal MS.
Yes.
The petitioner is challenging annexure G to the writ petition, my lords. Page 52. Lords, now, my lords, they are contemplating to take possession, my lords, from the petitioner. Therefore, I have filed application for a direction not to dispossess the petitioner, my lords, from the land. Lords, annexure G says, my lords, compensation amount is not sanctioned at all. Annexure G, page 52. Paragraph 2, my lords. ಮನವಿಯ ಬಗ್ಗೆ ಕಚೇರಿಯ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸುವಾಗಿ ಮಂಡಳಿ ವತಿಯಿಂದ ಹಾಸನ ವಿಮಾನ ನಿಲ್ದಾಣ ಸ್ಥಾಪಿಸುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬೋನಹಳ್ಳಿ, ಸಂಕೇನಹಳ್ಳಿ, ಲಕ್ಷ್ಮೀಸಾಗರ, ತೆಂಡಿಹಳ್ಳಿ, ದ್ಯಾವಲಾಪುರ ಮತ್ತು ಮೈಲನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಒಟ್ಟು 189.4 ಎಕರೆ ಜಮೀನಿಗೆ ಉಲ್ಲೇಖ 1ರಂತೆ 28/4 ಅಂತಿಮ ಸೂಚನೆ ಹೊರಡಿಸಿ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಸದರಿ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುವ ಜಮೀನುಗಳ
Earlier also you had made an interim prayer.
No, my lords, I have not approached.
It is there along with the petition itself.
I have not approached.
Interim prayer, I said.
Please, my lords. Earlier it was there. Lords, now there is a threat of dispossession is because of this meeting.
No interim directions are given.
Lords, this meeting now, my lords, on 21/3/25 it is passed. 21-3 meeting proceedings. First, there is a direction to complete the eviction process within 1 month.
Yes.
Now, award is not passed, compensation is not given as per Annexure G. Now, my lords, I am not objecting for acquisition. Annexure G may kindly be seen. ಸದರಿ ಭೂ ಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡಿರುವ ಜಮೀನುಗಳ ಭೂಮಾಲೀಕರಿಗೆ ಭೂಪರಿಹಾರ ಪಾವತಿಸುವ ಬಗ್ಗೆ ಕೇಂದ್ರ ಕಚೇರಿಯಿಂದ ಅನುದಾನ ಬಿಡುಗಡೆ ಆಗಿರುವುದಿಲ್ಲ. ಅನುದಾನ ಬಿಡುಗಡೆಯಾದ ನಂತರದಲ್ಲಿ ಭೂಪರಿಹಾರ ಪಾವತಿಸುವ ಬಗ್ಗೆ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. My lords, this is in 22 till now, my lords. Award is not passed, compensation is not paid. Now, my lords, by virtue of these proceedings, my lords, there is a direction to take possession within 1 month.
But the act also provides for that step.
Compensation has to be paid.
Please read the provision, KDLA. That is the whole difficulty. This the statute itself makes that provision.
Now, my lords,
anyway, you will be getting your compensation. What is the difficulty?
Illa, 22 in the they have not passed any award. This is 22, Annexure G. Now, my lords, if my lords the proceedings is implemented. Now, my lords, present position I have produced the photographs, my lords.
Asan airport.
ಹೌದು, Annexure H2 make
ಫಾರ್ಮೇಶನ್ ಆಗೋಗಿದೆಯಲ್ಲ?
ಇಲ್ಲ, ಏರ್ಪೋರ್ಟ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ಗಳು. ಪೇಜ್ 54 ಮೈ ಕೈಂಡ್ಲಿ ಬಿಸಿ 54. ಕಾಂಪೌಂಡ್ ಇಲ್ಲಿವರೆಗೂ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ವರೆಗೂ ತಂದು ನಿಲ್ಲಿಸಿದ್ದಾರೆ.
ಆಯ್ತು. ಏನು ವಾಟ್ ಇಸ್ ದಿ ಡಿಫಿಕಲ್ಟಿ?
ಕಾಂಪನ್ಸೇಷನ್ ಐ ಆಮ್ ಎಂಟೈಟಲ್.
ದಿ ಆಕ್ಟ್ ಮೇಕ್ಸ್
ಅವ್ರು ಕೊಡಲ್ಲ, ಬೇರೆ ಯಾರಿಗೋ ಕೊಟ್ಟಿದೀವಿ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನೋ
ಬೇರೆ ಯಾರಿಗೋ ಕೊಟ್ಟಿದೀವಿ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಂದ್ರೆ
ಬೇರೆ ಯಾರಿಗೋ 39 ಗುಂಟೆಗೆ ಕೊಟ್ಟಿದೀವಿ ನಿಮ್ಗೆ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಮತ್ತೆ
that must be determined.
It's a matter of reference then.
Yes, my lords. From 22, my lords, they cannot sleep over till 25. And now, my lords, the proceedings is passed.
On the one hand, you are saying they have not awarded the compensation.
Yes, my lord.
On the other hand, you are saying no, it has been given to some other person.
It is in respect of some other land, 39 guntas. I am the owner of 1 acre of land in 43 survey number. ಅವ್ರು 39 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ದಾನೆ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ they want to take possession. My lords, I am the owner from 61. There is a grant certificate in my favor. I have produced the title document.
Matter is called out. There is no representation for the respondent, KDB. Full stop. Release this matter on 15th of April.
Lords,
Tuesday we will see.
Dispossession may be stayed, my lords.
Tuesday.
My lords,
Next
tomorrow
week
they
of
will come.
Yes.
My lords, serial number 63, my lords.
Madam.
ಇದು ಬಿಲ್ಮನ್
56 ಆಯ್ತು.
ಬಿಲ್ಮನ್
ಅಲ್ಲ 56 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಏನಾಗಿದೆ? 56 ಆಗಿಲ್ಲ. ನಿಧಾನಕ್ಕೆ ಬರೋಣ ಸರ್.
ಆಗಿಲ್ಲ, ಹಂಗೆ
59
ಆಗಿಲ್ಲ.
58 ಇಂದ ಬರಬೇಕು. 58, 59, 60, 61, 60, 64. ಫುಲ್ ಚೇಂಬರ್ ಯಾವುದು?
Sir, 43 Tuesday is Thursday. 43 Tuesday and Thursday. 43.
15/4 ಸೊ ಮಂಗಳವಾರಕ್ಕೆ ಎರಡೂ ಸರ್ ಈಗ ನಂಬರ್ ಟ್ವೆಂಟಿ-4 ಕೊಟ್ಟಿದ್ದಾರೆ ಆಗಲಿ 24. What you want from me? First you say me, don't tell me. ಇಲ್ಲಮ್ಮ 15/4 ಅಂದ್ರೆ ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಮೆಮೊ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅದು 15/4 ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈ ಮೆಮೊಗೆ ಮತ್ತೆ ಬರೆಯಕ್ ಆಗೋದಿಲ್ಲ. ಆ ಮೆಮೊನೇ ಫಾಲೋ ಅಪ್ ಮಾಡಕ್ಕೆ ಇಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ನಂಬರ್ ಕೊಡಿ ನಾನು ಹೇಳ್ತೀನಿ. ಬ್ರಾಂಚ್ ಹೇಳ್ತೀನಿ ನಂಬರ್ ಹೇಳಿ ಮಾ. ಹಾ this acknowledgement can't be given there. Sir, I told them, but in spite of that, they say we have to get it to the office. Because it is once again I made representation alva. ಇದು ಕಮ್ಯುನಿಕೇಶನ್ ಆಗಲ್ಲಮ್ಮ. ನಾವು ಬರೀದು ನಮ್ಮ ಕಮ್ಯುನಿಕೇಶನ್ ನಾಟ್ ಬೇರೆ ಕೋರ್ಟ್ ಕಮ್ಯುನಿಕೇಶನ್ ಬರಲ್ಲ. ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಲ್ಲಿ this for high court not for the civil court. Sir, but it is posted on 15/4 ಹಾ ಅದನ್ನ ನೀವು ಹೋಗಿ ಹೇಳ್ಬೇಕು ಪೆಂಡಿಂಗ್ ಮೆನ್ಷನ್ ಇಷ್ಟು ನೀವು ಕೇಳಬಹುದು 15/4 ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೇಕು. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಮತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. 99 of 25 ಕೇಸ್ ನಂಬರ್ 79 ಅದು ಅದನ್ನ ಮಾಡಕ್ಕಾಗಲ್ಲ. The 12 foot for everything they are asking in the legal and ನಾವು ಅದೇನು ಮಾಡಕ್ಕಾಗಲ್ಲಮ್ಮ. ಹೋಗಿದೆ ಸರ್. ಅಲ್ಲ ಸೊ 15 ಕೊಡಿ.
ಏನು ಸರ್ ಹಲೋ ಸರಿ
ಒಂದೇ ಸರಿ 15 ಕೊಡಿ.
ಅರ್ಜೆಂಟ್ ಇತ್ತು ಅದಕ್ಕೋಸ್ಕರ
ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್. ಆ ಟೈಮ್ ಮಳೆ ಕೊಡಿ ತೊಂಬರ್ಬೇಕು.
ಸೈನ್ ಮಾಡಿ ತಂದು ಕೊಡೋದು ಲೇಟ್ ಮಾಡ್ಬಿಟ್ಟ ಅದಕ್ಕೋಸ್ಕರ ಲೇಟ್ ಆಗ್ಬಿಡ್ತು.
ಇಲ್ಲ ಅದಿಲ್ಲ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
ಅದು ಕೊಟ್ಟು ಹೇಳ್ರಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಅವ್ರಿಗೆ ಕಳ್ಸೋದಕ್ಕೆ ಅಂತ.
ಇಲ್ಲಮ್ಮ ಸರ್ ಇಬ್ಬರದು
ಏನು ಸರ್
ಹೇಳಿದಿಲ್ಲ ಸರ್ ಮತ್ತೆ ಅದನ್ನ ಕೇಳ್ಬಿಡಿ.
Hello, sir. Hello. Good afternoon, sir. Okay. Yeah, now I will only call you. ಅದು ಅವ್ರು ಬಂದಕ್ಕೆ ಹಲೋ ಫೈಲ್ ಆಗಿದೆ ಇವತ್ತು ಬೆಳಿಗ್ಗೆನೇ ಫೈಲ್ ಆಗಿದೆ ಎಫ್.ಆರ್. ನಂಬರ್ನ ನಿಮಗೆ ಸಾಯಂಕಾಲ ಹೋದ್ಮೇಲೆ ಕಳಿಸ್ತೀನಿ. ನಾನು ಕೋರ್ಟ್ನಲ್ಲಿ ಇದ್ದೀನಿ, ಸಾಯಂಕಾಲ ಹೋದ್ಮೇಲೆ ಓಕೆ. ಫೈಲ್ ಆಗಿದೆ. 5 ವರ್ಕಿಂಗ್ ಡೇ ಆದ್ಮೇಲೆ ನಂಬರ್ ಬರುತ್ತೆ. ನಂಬರ್ ಬಂದರೆ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಬರುತ್ತೆ ನೋಡ್ಬಿಟ್ಟು ಮುಂದಿನ ವಾರದಲ್ಲಿ ಬರಬೇಕು. 5 ವರ್ಕಿಂಗ್ ಡೇ ಮುಂದಿನ ವಾರ ಬರಲ್ಲ, ಅದ್ರ ಆಚೆ ವಾರ 21ನೇ ತಾರೀಕಿಂದ 26ನೇ ತಾರೀಕು ಬರುತ್ತೆ. ಓಕೆ. ಸರ್ ಆಯ್ತು ಊಟ ಇವಾಗ ಆಯ್ತು. ಕಳಿಸ್ತೀನಿ ಅಂತ ಕಳಿಸ್ತೀನಿ. ಆಯ್ತಾ? ಇಲ್ಲ ಕಳಿಸ್ತಾರೆ. ಎಸಿಗೆ ರಿಮಾಂಡ್ ಆಗುತ್ತೆ. ಕೊಡ್ತೀನಿ ಕೊಡ್ತೇನೆ ಅಂದರು. ಕೊಟ್ಟರೆ ನಿಮ್ಗೆ ಕಳಿಸ್ತೀನಿ, ಅದು ಹಾಕ್ಬಿಟ್ಟು ಮಂಗಳವಾರ. ಈಸಿ ನಾನು ಅದೇ ಮಧ್ಯಾಹ್ನ ಕೊಡ್ತೀನಿ ಆಗುತ್ತೆ ಅಂತ. ಸರ್ ಅದೇ ಒಂದು ಇದು 79 AB ಇದು. ಹಾಂ ಮೆಸೇಜ್ ಕಳಿಸಿರ ಮೆಸೇಜ್ ಈಗಿಲ್ಲ ಅವತ್ತಿಗೆ ನಾನು ಕೋರ್ಟ್ ಆಫೀಸರಿಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಬೇಕು. ನಾವು ಊಟ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಇಲ್ಲ ಇವ್ರು ಶೇಷ ಅವ್ರ ಹತ್ರ ಇದೆಯಂತೆ. ನೋಡೋದು ನಾನೇ 2 ನಿಮಿಷಕ್ಕೆ ನೋಡ್ತೀನಿ ಗೊತ್ತಾಗ. ಇನ್ನ ಬರಲ್ಲ ಏನೋ ಬಂದಿಲ್ಲ ಅವರು ಕೇಸ್ ಹೆಂಗ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾರೆ ಮಾಡಾಯ್ತಾ ಏನೋ ಏನು ಕಟ್ಟಾಯ್ತಾ ನಾನು ಹೇಳಿದ್ದೆಲ್ಲ ಹಾಕಿದ್ಯಾ ನಾನು ಹೇಳಿದ್ದೆಲ್ಲ ಹಾಕಿದ್ದೀನಪ್ಪ ಈಗಿನ ಡೇಟು ಇದು ನಾವು ಅಟೆಂಡ್ ನಾನೇ ಬರ್ತಿದ್ದೆ ಥರ್ಡ್ ಕೇಸ್ 8ರಲ್ಲಿದ್ದೇನೆ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಇವತ್ತಿಲ್ಲ ನಾವು ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಫೋನ್ ಮಾಡುತ್ತಾ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲೋಕದಾತಿ ಕಳಿಸ್ತಾರೆ ಅಂತ ಹೇಳಿ ಅವ್ರು ಇನ್ನ ಹಂಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಇನ್ನ ರೀಚ್ ಆಗಿಲ್ಲ ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ತಾಂಡ್ರೆ ಮುಗಿಸ ಕೊಡೋದು ತಾಂಡ್ಲ ಅಂದ್ರೆ ಮುಗಿಸ್ಬೋದು ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ರೆ ಲಾಸ್ಟ್ ಹೇಳಲ್ಲ ಏನು ವಾಟ್ಸ ಮಾಡ್ತು ನೀವು ಡಿಸ್ಕನೆಕ್ಟ್ ವಾಟ್ಸ ಮಾಡ್ತು ಎಲ್ಲ ಸ್ಟೋರಿ ಎಲ್ಲ ಕೇಳಲ್ಲ ಕೇಳೋದು ಇಲ್ಲ ರಿಜೆಕ್ಟೆಡ್ ಯಾಕೆ ಹೇಳ್ಬೇಕಲ್ಲ ರೀಚ್ ಆದ್ಮೇಲೆ ಬಂದಿದೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ನಾನು ಬರ್ಬೋದು ಆದ್ರೆ ಅದು ಬರ್ಬೇಕು ನಾನು ಹೋಗ್ಬಿಡ್ತಾರೆ
VP ಇದೆಯಾ ಏನ್ ಸ್ಟೇಜು
ಮಾಡಲ್ಲ ಅನ್ಸುತ್ತೆ ಸರ್, ಅವರೇ ಬಂದ್ರು ಕೇಳೋಣ. ಮಾಡಲ್ಲ ಅನ್ಸುತ್ತೆ ಸರ್.
ತಗೊಂತಾರೆ ತಗೊಂಬಿಡಿ ಅದನ್ನ.
ಕೇಳ್ಬೇಕು ಸರ್.
ಹೇಳಿ ಕೇಳಿಸ್ತಿದೆ. ಹಾ ತಗೊಂತೇವೆ 62 ತಗೊಂತೇವೆ. Competent authority ಎಲ್ಲೇ to withdraw the amount ತಗೊಂತಾರೆ. ಕೂತ್ಕೊಳ್ಳಿ, ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಡಿ. ಹಾ
ನಮ್ದೆಲ್ಲ ಹಾಗೆ
ಹಳೆದು 2022
ಯಾವ ಆಶಯ ಮೇಡಮ್ ಇದೆ ಮೇಡಮ್ ಇವಾಗಲೇ ಇದಕ್ಕೆ ಟೈಮ್ ಕೊಡಲ್ಲ ಇವಾಗ ಕಾಲ್ ಮಾಡೋದಕ್ಕೆ ಟೈಮ್ ಇ ಪಿ ಇರೋದು ಇನ್ನ ಮುಂದೆ ಮೇಡಮ್ ಆದ್ಮೇಲೆ ಇ ಪಿ ಇರೋದು ಇ ಪಿ ಇರೋದು 64 ಇ ಪಿ ಶಿವರಾಮ್ ಶಿವರಾಮ್ ಎಲ್ಲಿದ್ದಾರೆ 60 ಕರೀತಾರೆ ಮೇಡಮ್ 20 ಸ್ಟಾರ್ಟ್ ಮಾಡೋದು 20 ಮಾಡ್ಬೋದು ಇದೆಲ್ಲ 230 ಇಂದಾನೆ.
ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್
ಹೇಳ್ಬಿಡು. ಅವರಿದ್ದಾರೆ ಅಪೋಸಿಟ್ ಇದ್ದಾರೆ ನೋಡಿ. ಇದೇ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲೆಲ್ಲ ಇರ್ತಾರೆ ನೋಡಿ. ಚಂದ್ರಶೇಖರ್. ನಂಬರ್ ಕೊಟ್ಟು back to assistant commissioner
ಸರ್
ಲೇಟೆಸ್ಟ್ ಇದೆ 7821 ಅಂತ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅದು ಇದೆ.
ಇವತ್ತು ಬಂದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ WP24 ಪ್ರಿಂಟ್ ಫೈನಲ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಬಂದ್ರೆ ನಾನು ಬಿಸಿ ಕ್ಲಿಯರ್ ಇಲ್ಲ ಮಳೆ ಯಾವಾಗ 7821 of 21 ಇದನ್ನೇ ರೆಫರೆನ್ಸ್ ಇದೆ. ವರ್ಷದ ಬೆಳೆ ಸುಸ್ತಾಗ್ಬಿಡುತ್ತೆ. ಇವತ್ತು ಇತ್ತ ಇವತ್ತು 26 ಕೊಟ್ಟಿದ್ದೀವಿ. ಮ್ಯಾಟ್ರು ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ ಇಲ್ಲಿ ಈ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಹೋಗ್ಬಿಟ್ರೆ ಇದೆಲ್ಲ ಮ್ಯಾಟ್ರ್ ಹೋಗ್ತದೆ. ಎರಡು ಇಲ್ಲ ಮೂರು ಮ್ಯಾಟ್ರ್ ಹೋಗುತ್ತೆ.
ಪಾಸ್ವರ್ಡ್ ಯಾರು ಆಗಿಲ್ಲ.
ಡಿಸ್ಪೋಸಲ್ ಆಗ್ಬೇಕು.
ಮುಂದೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ
Small submission, Your Lordship. Serial number 62, Your Lordship. The respondent is here. I am for the petitioner. It was for the office compliance, Your Lordship. The file has arrived only yesterday, Your Lordship. Some 62, Your Lordship.
And for the respondents in the matter.
Respondent is also very much present. Yeah, accommodation may be given, Your Lordship.
Please.
Two matters are there. Connected.
Serial number 62 at the request of learned counsel for
Petitioner, Your Lordship.
ಯಾವ ಬೇರೆ ಬೇರೆ ಇದಾವಲ್ರಿ?
ಎರಡೈತೆ ಸ್ವಾಮಿ. 62
ಒಂದರಲ್ಲಿ ಶ್ರೀನಿವಾಸ್, ಇನ್ನೊಂದರಲ್ಲಿ ಸುಹಾಸ್.
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಎರಡನಲ್ಲಿನೂ NOC ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ?
ಇಲ್ಲ, ತೋರಿಸಿಲ್ಲ. ಸೈಯದ್ ಉಮರ್ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಹೇಳಿದ್ರಿ ಸರ್. ಚೇಕ್ ಮಾಡಿ. ಒಂದಲ್ಲಿ ತೋರಿಸಿಲ್ಲ, ಒಂದಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ.
ಸೈಯದ್ ಉಮರ್?
ಹೌದು, ಸೈಯದ್ ಉಮರ್.
ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
ಇಲ್ಲ, ಫಾರ್ ಪೆಟಿಷನರ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
ಸೈಯದ್ ಉಮರ್ ಅಂತ ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ತೋರಿಸಿದಾರಲ್ರಿ?
ಹೌದು, ಅದು ಪೆಟಿಷನರ್ ಅಂತ ತೋರಿಸಬೇಕು ಸರ್.
Mistake, my lords. Or last time they had submitted saying that, my lords, that he is filing NOC for the petitioners.
Petitioner ಅಂತ ಹೇಳಿ.
At the request of learned counsel Shri Umar, Syed Umar released these matters on
last week. Last week, Your Lordship. After 22nd. ಅದರಲ್ಲಿ ತುಂಬಾ ಆಫೀಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಐತೆ ಸ್ವಾಮಿ. ನನಗೆ NOC ಬಂದಿರೋದು.
ಅದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ ಫಸ್ಟ್ ಟೈಮ್.
ಇಲ್ಲ ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ಸ್, Your Lordship.
There is no interim orders.
Interim order ಐತೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ
ಅವ್ರದ್ದು ಏನು ಇದಿಲ್ಲ.
There is an interim order, my lords. The proceedings have not been stayed. Only the interim order, my lords, which is passed by the trial court is stayed, my lords. I would request, my lords, in case they are seeking for some adjournment, my lords. I would request any date, my lords, after 22nd, my lords.
Release this matter on 23rd of April.
Please, my lords.
Yes. Serial number 54 24 at the request of learned counsel for petitioner release this matter on 22nd.
Serial number 49, my lords. Right, 2 weeks time, my lords.
Every time you're asking for adjournment like this.
My lords, we'll make a proper representation before the BDM, my lords.
This matter was heard on the last occasion, my lords. Very much, in view of my representation, this order came to be passed. Lords, he has built up my lords, construction in the road.
You are appearing for whom?
I appear for the impleading applicant. In fact, I gave the representation to the BBMP merits. On that basis, this order came to be passed.
Lords,
It was heard for some time on the last occasion. It took time.
2 weeks time, my lord, because we'll make the proper representation of the BDM, my lords. Because already we have been in annexed H, we have been allotted some site, my lords. His father's name has been added as a.
What do you say? No objection.
Lords, I have objection because there is an interim order, my lords. Now, because of the interim order, my lords, there is some.
My lords, 2 weeks time, my lords, we will. 2 weeks time, my lords, we will make the proper representation so that we can get a compensated land. Exchange of land, my lords, because
22nd.
As a document annexed H, we give up. We have
Number 49.
49 minutes.
At the request of learned counsel for petitioner release this matter on 22nd.
21st.
21st.
Yes.
All right.
Serial number 60, my lord.
Interim order may be extended, my lords.
Interim order stands at
22nd, 22nd or 23rd August.
60.
ಜಡ್ಜ್ಮೆಂಟ್ ಗೆ ಪೋಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ರೆ ಅದೇ ಸೆಟಲ್ಮೆಂಟ್ ಏನಿಲ್ಲ
So I'll proceed to pass orders.
ಸೆಟಲ್ಮೆಂಟ್ ಏನಿಲ್ಲ
No. Yes.
Serial number 51, my lord.
No adjournment.
Serial number 50.
I've heard the learned senior counsel, learned counsel, and because they said they'll try for a settlement, I adjourn the matter. I would have passed the order that day itself. Yes.
Serial number 51, my lord. Personal conveyance, I request my lord that
51.
request that may be posted on 16th or 17th, my lord.
Who's in
I'm
other
the
side?
petitioner, my lord.
Other side is not here.
Present, my lord.
Mr. Sagar, PB.
To the respondent. I heard this matter, my lords. They had taken time, my lords, to look into the judgment that was placed by me. For that reason, it was adjourned.
I seek for a short accommodation, my lord. 16th or 17th may be listed at my lord's convenience. We will address the arguments, my lord.
serial number
50.
Serial number 51. At the request of learned counsel for petitioner, release this matter on 16th of April.
Please, my lord.
All right. Yes. Yes.
60, my lord.
No.
My lord, serial number 55.
Yes.
Senior counsel held up in some parted matter, my lord. So please give me one shorter date.
Mr. Karthikeyan.
Please, my lords.
Serial number 55.
Please.
At the request of learned counsel for petitioners.
Yes, my lord.
Release this matter on
After vacations or next week.
on 24th of April.
Okay, ma'am.
Yes.
Obliged.
Please.
Announcement of orders at 2:30 PM, serial number 58. Abhinang, yes.
The writ petition is allowed. The impugned order of rejection at annexure W and the impugned technical evaluation report dated 4/6/2024 at annexure Y are hereby quashed and set aside. The agreement dated 9/7/2024 and purchase orders dated 10/7/2024 and the letter of intent dated 27/6/2024 issued by the first respondent in favor of the fourth respondent are also quashed and set aside. Consequently, respondents number 1 to 3 are hereby directed to reconsider the price bids of the petitioner submitted pursuant to tender notification dated so and so for supply of 65 mm and 125 mm forged grinding media balls in the light of the observations made herein above. If possible, endeavor should be made by the first respondent to award contract to the petitioner as well as the fourth respondent on acceptable terms.
Grateful minutes.
ಯಾವುದು ಇದಾ ಎಲೆಕ್ಷನ್ ಪೆಟಿಷನ್ ಹೌದಾ? ಮತ್ತೆ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಬಂದಿರಿ ಯಾವ ಮ್ಯಾಟ್ರಿಗೆ?
Next matter, 59, 230 matter.
59.
59.
Sorry,
59.
In fact, we have filed our synopsis pursuant to your lordship's direction, Manoj. Along with the files last time, we had given it to your lordships, Manoj. Lordships are directed whether 2-3 clarification, whether notice was issued prior to cancelling allotment made in favor of the respondents, Manoj. What is the procedure followed? We filed a synopsis and a sequence of events, what has happened, Manoj.
Notes illiದೆ.
That was filed on last date of hearing, Manoj.
27/3.
Please.
27/3 ಹಾಕಿದ್ದಾರೆ.
If your lordships are aware, total extent of land is around 21 acres, what was preliminarily sought to be acquired, Manoj. In this petition, what is sought to be challenged is allotment of 9 acres and odd in favor of the contesting respondents. 2.5 acres we have denoted. Can I give?
That's on 27th. It was filed before 27/3ಕ್ಕೆ.
Can I give?
Open court ಅಲ್ಲಿ ಕೊಟ್ಟರು. Lordships.
Your lordship are pleased to make notes on that also. ಇದಂತ ತೋರಿಸಿ ಕೋಡ್ ಆಫೀಸರ್ ಈ ತರ ಇದೆ ನೋಡಿ, ಇದೆ ಈ ತರ ಇದೆ ನೋಡಿ. ಕರೆಕ್ಟ್.
26/3.
Just to recapitulate, Manoj, if your lordship sees, the gist is given in page number, Manoj.
27.
Correct, 27. Manoj. 27.
No, I had, I think if I remember correct, I had asked for information to show that you had issued notice to the petitioner, kept him informed regarding the allotment you sought to make to the other party.
That is not them.
Information is what I had called.
That is not them.
It is not there.
Not them. That's what.
Last time argument he.
Page 37 may be kindly seen, Manoj. Page 37, just to recapitulate. Tabular form, Manoj. Out of total extent of 21 acres, 2 guntas, 9 acres is page, I'm sorry, Manoj, page 37. Last page, Manoj. Total acquired is, lordship, please. Just to recapitulate, Manoj. 21 acres, 2 guntas is the total extent of land. The subject matter of this writ petition is 9 acres, 34.5 guntas, Manoj. Next, 1 acre, 3 guntas, 27 guntas and 29.5 guntas, which is approximately 2.5 acres, Manoj, has been given to the landowners, Manoj. But they formed a company, to them we have allotted this land, not in the individual name, Manoj. Insofar as 2 acres, 39 guntas is denotified, Manoj. And remaining what is available, which is vacant as on today, Manoj, is 5 acres, 29 guntas. Anyway, Manoj, this 6 acres, 11 guntas, we have cleared a project. As I mentioned to your lordship, we are not acting on it, Manoj. 5 acres, 29 guntas is vacant, Manoj, which we are, because the matter is sub judice, Manoj, we are not taking any action. But I thought, as a matter of fact, I should tell that project is cleared, but allotment is not made, Manoj. Insofar.
What do you want to do now?
Manoj, subject.
Having regard to the fact that these lands were notified at the behest of the petitioner.
Only once.
Entire 21 acres.
2 guntas.
2 guntas.
Manoj, insofar as Manoj, insofar as 5 acres, Manoj, independent, I'll seek instructions, Manoj, whether what can be done with regard to 5 acres, 29 guntas, whether how to go about it, Manoj. Insofar as 9 acres, 20, Manoj, I think my learned friend, because any statement made by me should not prejudice.
9 acres, 29 guntas and 6 acres, 11 guntas.
Illa, Manoj, 5 acres, 29, not
so 6 acres, 11 guntas.
Project clear ಮಾಡಿದ್ದೇವೆ, but availability
ಇರೋದು 5 ಎಕರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ, 5 acres, 29 guntas.
Sufficient.
No, I am saying, my lords, the entire thing, if your lordship sees 9 acres, 34.5 guntas ಇದೆಯಲ್ಲ.
That is my learned friend will have to.
Fifth respondent allot ಆಗಿರೋದು after the writ petition. Now, my lords, the other one, 1 acre, 3 guntas and 27 guntas.
What I am trying to ask you is, will you be satisfied if this 5 acres, 29 guntas and 6 acres 11 guntas are given to you.
ಇಲ್ಲ 6 acres 11
6
ಗುಂಟಾಸ್
acres
ಇಲ್ಲ
ಇಲ್ಲ ಮಲ್ಲ 6
ಅದಿಲ್ಲ
acres ಇಲ್ಲ.
ಅವ್ರು ಅದೇ ಮಿಸ್ಟೇಕ್
No,
ತೋರಿಸ್ತಾರೆ.
no, not mistake. Your Lordship, may kindly see the first page, madam.
ಅದು approval
Mistake
ಕೊಟ್ಟಿರೋದು
illa.
sir.
First page 27 ನೋಡಿ madam. Page 27. It has to be read. Page
But
27,
the
last
approval
two columns, my lord. Balance land available, we have mentioned is 5 acres 29 guntas. Pending proposal is 6 acres 11 guntas is there. So pending proposal, it has been approved to somebody else. We will not give it to them, my lord. What is balance before for Lordship's consideration is 5 acres 29, which is vacant, which is not the subject matter of this petition. But as your Lordship pointed out, acquisition was initially a preliminary notification, has been issued in the name of the petitioner herein.
Therefore, I am asking the learned senior
Please,
counsel,
my lord.
what would you say
My lords,
on instruction?
my instructions are, my lords, 5 acres 29 guntas at least on an immediate basis, at least they can allot it to us. So far as the others, my lords, it has to necessarily go, because my lords, we are pointing out.
My lords, I'll address
Nimsha,
arguments in
let
the
me
matter.
just, I am only saying, after that.
I thought, my lords, my learned senior friend has already been heard in the matter. I'm sorry.
9 acres 34.5 guntas has been allotted to fifth respondent only after filing of writ. Then the last page I am referring to, my lords, 37 only, page number 37.
Yes.
Then 1 acre 3 guntas and 27 guntas, that is allotted to RPB Tech Park, PBR Infotech.
I have
Ella
understood.
after writ petition.
Correct, I have understood. What they are trying to say is, it is given to the landlord or landowner only,
Landowners are
but
applied.
in a different name. He has registered a company, so it is given to that
Lords,
company.
all
That is
this-
what they are trying to say.
RPB Tech Park,
Make an
PBR
affidavit
Infotech.
act, affidavit act, we are
Allah.
not hiding, man. Fact.
Alla,
No, no, that
RPB
is why
Tech
I am
Park.
asking you, will you be satisfied if this 5 acres 29 guntas and 6 acres 11 guntas are given to you?
Lords, 5 acres 29 guntas ಅಷ್ಟೇ ಇರೋದು, 611 ಇಲ್ಲ ಅಲ್ಲಿ.
611, they have proposed to allot, it is not allotted, please understand.
No,
No, my
Lords,
lord,
the
can I
land
make
is
it
not
clear?
there, they are made.
No, ma'am,
That's what
can I
the land-
make it clear, my lord? My lord, what is the, what is available as on today, unallotted land is only 5 acres 29.
What about
This
6
6
acres,
acres
11
is,
guntas?
we are actually, my lord, this, instead of, the 6 acres was also, project is approved in 5 acres 29 guntas, my lord. This 6 acres 11 guntas forms part of 5 acre 29.
ಅಲ್ಲಿ 5 my lords, your lordship gets
6
that
acres 11
529.
guntas forms part of 5 acres 29, my lord.
ಒಂದ್ ನಿಮಿಷ, ಇದು ಈ 6 acres 11 guntas ತೆಗೆದ್ಬಿಟ್ರೆ
ಹಾ,
ಮಿಕ್ಕಿದ್ದು will
ಬರೀ 5 ಎಕರೆ 29 ಅಷ್ಟೇ ಇರೋದು.
no, no, ಅದ್ ಮಿಕ್ಕಿದೆಲ್ಲ ಸೇರಿಸಿದ್ರೆ it will come to
21 acres 2 guntas. ಹೌದು.
ಇಲ್ಲ, it will come up to
6 acres 11
18 acres. 18 acres.
18 acres.
ಯಾಕಂದ್ರೆ ಡಿನೋಟಿಫೈ ಆಗಿರೋದು 2
2
acres
acres
39 guntas. Your lordship may see the one next to 5 acres.
18 acre ಬರುತ್ತೆ.
That this 2 acres 39 has been denotified. What is available will be
21 acres 2 guntas ಅಲ್ಲ.
correct.
ಹೌದು.
So what is finally acquired is only 18 acres.
I bow down to your lordship.
ಅಕ್ವೈರ್ ಮಾಡಿದ 21.5, ಡಿನೋಟಿಫೈ ಮಾಡ್ಯಾರ 2.5.
Correct.
Available land.
About 18 acres is available.
Correct.
Was
So ಇದನ್ನೆಲ್ಲ ಸೇರಿಸಿದ್ರೆ excluding 6 acres 11 guntas
21.2 ಬರುತ್ತೆ.
ಎಷ್ಟು ಬರುತ್ತೆ?
21.2 ಅದ್ರಲ್ಲಿ ಡಿನೋಟಿಫಿಕೇಶನ್ ತೋರಿಸಿದ್ದಾರೆ. ಸೊ ಎಲ್ಲ ಸೇರಿದ್ರೆ 21.2 ಬರುತ್ತೆ. ಡಿನೋಟಿಫಿಕೇಶನ್ ತೆಗೆದ್ರೆ 18.
18 acres and odd will come. Out of 18, my learned friend's client has been given 9
He has
acres.
been given 9 and
34.5
34.5 guntas straight away. And that too.
So you are not happy with this 5 acres?
5 acres. What we had filed an IA is, at least for the present, allot this at least, because otherwise, my lord, what's happening is, while the writ is pending, the right hand doesn't know what left hand is doing.
Allah, sometimes not, let him not say.
Allah,
Sometimes they know more, that's the problem. I'm not.
Lords, may I just, Lords, before your lordships, Lords, so far as that 5 acres.
Having regard to
Court officer. Your lordship.
Can I make a submission, Lords, regarding even that 5 acres?
filed at the hands of
ಆಗಿಲ್ಲಲ್ಲ?
the respond number 1 KDP.
For your lordship's kind reference, easy reference, my lord, sketch we have given.
5 acres 29 guntas of land are available without being allotted to any other entity. Stop. Therefore, till the disposal of this writ petition, 5 acres 29 guntas shall not be allotted to any other person.
Please,
Yes.
In fact, we have said it should be allotted to
Illa,
us.
my lord, that would be a fair way of dealing with things.
We will hear the matter.
Allah,
Please, minutes.
my lord, your lordship, in fact, my statement itself is, my lord, we will not allot. In spite the project is approved, we will not allot. Let it be there. And this is just for your lordship's kind reference, my lord. Total
No, there is
acquisition.
nothing now. If the matters to be heard and disposed of,
Correct.
you tell me the date, I'll hear.
That's before this.
Monday or Tuesday, my lords.
Just one submission. Your lordship, can you take the sketch, my lord?
Yes.
So that total acquired 21 acres, left out 2 acres 17, RR Platinum, that is my learned friend's client, my lord, 9 acres 34 and guntas. This Kanani Tech Park is three people, companies, my lord, 2 acres 29 and a half guntas. Remaining land is 5 acres 29 guntas, my lord.
Sorry.
That is all.
Now, the only issue is whether you could have allotted it to.
That's the point, my lord.
Lords, Lords, the only question, my lords, if I were to submit, the question is whether the petitioner could maintain this writ petition at all or not. That's the first question which is required to be considered by your lordships.
Still consider.
Lords, when can, of course, lordships
Lord,
have
may
heard
I
the
make
matter
one more
substantially, my
submission,
lords.
Your lordship may fix a date prior to this vacation. Only one submission.
We will
15th or 16th.
fix it next week itself.
Innೊಂದು submission, no? This PBR in RPB and PBR and CVS, our piece ಕೊಟ್ಟಿಯಾರಲ್ಲ, ಅವ್ರದ್ದು impleading we had filed and they are served. If that they are allowed to be impleaded, my lords, because if our ಮೇಲೂ relief ಕೇಳ.
ಯಾವುದು ಐ ಅದು?
IA 1 of 24. IA 1 of 24, my lords. Last time there was a counsel on their behalf.
In fact, I have no objection to you given the matter. I also tried my objections to the matter.
ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಜನ ಕೇಳಿದ್ವಿ, ಬಟ್ ಫಾರ್ ದಿ ಪ್ರೆಸೆಂಟ್ ಓನ್ಲಿ
ಎಲ್ರು ಇದು ಐ ಫಾರ್ ಇಂಪ್ಲೀಟಿಂಗ್.
ಅದ್ರಲ್ಲಿ ತುಂಬಾ ಜನ ಕೇಳಿದೀವಿ, ಬಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ 6, 7, 9 ಅಲ್ಲ 6, 7 and 9 in that IA 1 of 24 ಅಲ್ಲಿ. ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ
Order on IA number 1 of 2024. First ಇದನ್ನ ಬರ್ಕೊಂಡು ಆಮೇಲೆ this application is filed by the petitioners seeking to implead.
ಅದರಲ್ಲಿ ಪ್ರಪೋಸ್ 8th ರೆಸ್ಪಾಂಡೆಂಟ್ ಬೇಕಾಗಿಲ್ಲ. 6, 7 and 9 ಅದ್ರಲ್ಲಿ ತೋರಿಸಿದ್ರೆ ಅವ್ರು 3 ಜನ ಬೇಕು ಅಷ್ಟೇ.
6, 7 and 8.
6, 7 and 9 my lords. 8 ಬೇಡ.
6, 7 and 9 ಅಷ್ಟೇ. ಇವ್ರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡಿದ್ರೆ ಆಗ್ಲೇ ಕರ್ನಾಟಕ ಉದ್ಯೋಗ ಮಿತ್ರ ಆಗಿದೆಯಾ?
ಉದ್ಯೋಗ ಮಿತ್ರ ಇದ್ದಾರೆ ಇವ್ರು.
My learned friend appears for
ಸ್ಟೇಟ್ ಹೈ ಲೆವೆಲ್ ಕಮಿಟಿ ಅಂತ ಕೇಳಿದೀವಿ, ಅದು ಬೇಕಾಗಿಲ್ಲ ಸದ್ಯಕ್ಕೆ. ಸ್ಟೇಟ್ ಹೈ ಲೆವೆಲ್ ಕ್ಲಿಯರೆನ್ಸ್ ಕಮಿಟಿ
ಇರ್ಲಿ ಬಿಡಿ.
Oh, very well. We'll implead them.
To implead.
But ಉದ್ಯೋಗ ಮಿತ್ರ.
Proposed respondents number 6 to
6, 7 and 8. 9. This will be 9.
We'll say that we will let you. To the outmatter.
On the ground that the respondent KDB has allotted or proposed to allot certain extent of land involved in this writ petition. Full stop. Proposed respondent number 10 is the Karnataka Udyoga Mitra. Full stop. The learned counsels on the for the respondents have no objection to allow the application. Full stop. However, learned senior counsel appearing for the petitioner submits that proposed respondent number 8 may not be necessary. Full stop. Next para. Consequently, application is allowed while permitting proposed response number 6, 7, 9 and 10 to be brought on record as party respondents to the proceedings. Learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Yes. Adadmela.
They are represented already. ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ದಾರೆ.
Statement of objections, if any, on behalf of the newly impleaded respondents may be filed within the next date of here. Yes.
16th, can I request my lords at 2:30?
16th ಬೇಡ, 17th or 16th ಧಾರವಾಡ ಅಲ್ಲಿ ಇದೆ.
Can it be on 15th itself, my lords, at 2:30? 15th.
ಆಯ್ತು, 15th ನನ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. 16th ಒಂದ್ ದಿವಸ ನನ್ಗೆ I will be in ಧಾರವಾಡ, that's why.
15th.
Please do. 15th. ಪರವಾಗಿಲ್ಲ, ಏನು ಅವ್ರು ಮಾಡ್ತಾರೆ.
ಇವ್ರಿಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಕ್ಕೂ ಟೈಮ್ ಇಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ 21st or 22nd ಅದ್ ಬಿಟ್ರೆ ರಜಾ ಇದೆ. ನನ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
We'll commence, my lord. So because this
We
is
can't
in two
commence,
parts.
we have to
My
commence.
lords, this is in two parts. Let them have their.
He is not saying ಬೇಡ ಅಂತ ಹೇಳ್ತಲ್ಲ ಅವರು. I am asking you.
ಅವ್ರ ಕೌಂಟರ್.
My lords, that's the reason why I said, my lord, this is in two parts. One is the land which is allotted to me, and the other one is the lands which are allotted to them.
And it's in land which is not allotted also.
And the land which is not allotted. My lords, the reason why I am submitting this is, my lords, so far as the lands allotted to me is concerned, is of the year 2012, which is under challenge before the lordships.
This matters on 21st of April.
Please.
All right.
The earlier interim order may kindly be.
Lords, 21st of April at 2:30, my lords, specifically if you can, lords. 21st of April at 2:30.
2:30. Yes.
That will file the amended cost title ಹಾಕಿದ್ರೆ ಸಾಕು.
Amended cost title.
Please.
ಹೌದು.
Number 60, B.K. Chandrasekhar.
And
The
for the,
heard reserved. Yes.
my lords, my submission may be recorded, my lords.
Yes.
We wanted to submit some citation, my lords.
Nothing more.
I beg my lords.
Yes.
Kindly
Serial number
record that.
61, Shivkumar.
On the last occasion, the 18th of February, I have given my written note, one pager, two pager.
Yes.
And with the compilation of the judgments on review, my lord. This is a review petition, and my submission or limited submission is that the error or the mistake apparent on the face of the record or any other sufficient cause includes apparent non-consideration of the ground. And that is the SNS mineral, which I have last time, my lord, I have given a judgment of 2007, the Honorable Supreme Court. If my lord has that written note or not.
Yes, I have it.
So the first submission, lord, SNS mineral, it permits your lordships a jurisdiction on the review that if A, B, C, D is the ground which your lordships have factored to form an opinion, and E, F, G, H grounds which I have submitted, I have averred, and it is not adjudicated, then your lordships have a jurisdiction on the ground that it includes the apparent non-consideration of the grounds. That's SNS mineral. The point number one. Now, how to demonstrate, my lord, that these are the grounds which has not come in consideration. The page number 20 of my lord's impugned judgment, a review, paragraph number 10. This is the whole sum and substance of my lord's observation, because prior to that, your lordships have discussed the section 16, 17, and 20C. Now, if I may read below the paragraph number 10.
Yes.
Applying the law as declared by the Honorable Supreme Court, this Honorable Court finds in the present case that admittedly there is no written agreement between the parties. Therefore, it would be futile on the part of the defendants to contend there is an agreement between the parties restricting the jurisdiction of the court to decide the disputes between the parties in terms of the invoices raised by the defendants. This is the first observation, my lord. And then your lordship has gone on saying, reliance placed by the trial court on Patel brothers, where it was held that the jurisdiction of a court cannot be taken away merely because in the letterhead of the defendant, he had printed the words subject to Berhampur jurisdiction cannot be faulted. This court concurs with the opinion of the Madras High Court, where it was held that such orders, such words were not sufficient to constitute a contracting out of the jurisdiction of a particular court or vesting it in a particular court. Then second, it is not disputed by the defendant that the said invoices, the address of the plaintiff is printed as Bangalore, and the communication between the parties also refer to the address of the plaintiff at Bangalore. Therefore, the invocation of the jurisdiction of the commercial court at Bangalore under section 20C is permissible. It is permissible for the plaintiff to contend that the part of the cause of action arose in Bangalore. That's the entire submission, my lord. So what my lord has stated, first part, saying that it has concurred with the my lord, the Patel brothers, 1958 Chennai single judgment. That's point number one. Why? It's saying that mere use of the word subject to jurisdiction of X does not necessarily mean that ousting a lawful jurisdiction conferred under section 16 to 20. That's the proposition in that. Your lordship has concurred to that effect. But what is the fact of the case, my lord, is this. In our case, even in the Patel brothers, my lord, is the part cause of action arose in the Chennai because the cotton bale were to be delivered at the Chennai from the Bombay. Now the Bombay did not comply there, and therefore they have raised the issue of, they filed a suit for damages in Chennai. The Bombay, the defendant claimed the issue, since we have issued the invoice subjecting the jurisdiction to Bombay, therefore the Chennai doesn't have jurisdiction, which the Patel brother rejected. So therefore, the Patel brother, in fact, supports my case that the part cause of action arose at the Chennai. In our case, if we extrapolate the facts and the reasoning of the Patel brothers, in our case, it is actually the Cuttack. So in other words, if extrapolated the entire Patel brothers, the case stands in my favor, and which to that extent, my lord, has not taken note of that submission. Point number one. Number two, your lordships have formed the opinion on the basis of the part cause of action on 2 points. That says that the invoice contains the address at Bangalore. Admittedly, it is true. But the invoice actually was delivered not by email, not by post. It is actually delivered at the Cuttack. That's a fact. That is not factored. Number two, the communication, your lordships have taken the second fact for a forming opinion part cause of action, is that the communication contains also admittedly the Bangalore address. We also don't dispute that. That is a communication, my lord, is actually a reply to a legal notice, a demand notice, which happened on the 30th of March 2023, pursuant to which the entire dispute arose. So what's my cause of action? Paragraph number 3.4 for a moment, your lordships may kindly turn, of my submissions in my review. Because the following averments, this is at the page number 8. Because the petitioner's pointed submission made on 3rd of September 2024, where your lordships reserved the judgment, through his written note dated 19th of August 2024, are not inadvertently adjudicated. Well, this is the paragraph number 3.3, 3.4. I want to read 3.4. Because the following averments.
3.4 of what?
3.4 of the review petition at page number 8. Review petition at page number 8. That's my ground.
This tabular column, paragraph number 10.
No, I am on the review petition, page number 9, page number 8, paragraph number 3.4. There is some page number differences there, my lord. Up to 7th page is correct. 3.4 paragraph.
All right.
Which starts with because the following averments, as borne out from the pleadings and the documents, are not adverted to, proving no part of the cause of action ever remotely accrued within the local limit of Bangalore. A. Plaintiffs supplied grapes to various places all over India by lorry, trucks, and informed defendants about the arrival of the grapes at defendant's destination at Cuttack in front of my shop. That is the para number 5 and 6 of the plaint. I'm only quoting from there. Then, as per the business practices, defendants, after receiving and unloading at Cuttack grapes, undertakes the responsibility of selling grapes as a commission agent. Paragraph number 7 of plaint. As a commission agent, defendants also entitled for commission at Cuttack, and balance of sale proceeds shall be paid at Cuttack to the plaintiff after deducting at Cuttack sale commission, para 7. As per the business practices adopted at Cuttack by defendants, it has maintained at Cuttack statements of the account reflecting both debit and credit balance. Paragraph number 7. Then E. Defendants also paid at Cuttack various amounts to the plaintiff towards grapes supplied at Cuttack. Once grapes are received at Cuttack by defendants, it is their duty to pay at Cuttack the amount, as per the various supplies made at Cuttack by the plaintiff, defendants have submitted at Cuttack statement of accounts invoice. So this invoice, which your lordships have relied at the page number 20, saying that it contains the address of the Bangalore, well, this is actually submitted to the local guy of this, the respondent or the plaintiff, appointed at the Cuttack. He has appointed an employee there who brings this lorry to my shop. I then suppose, for example, in a day, a particular truck is not coming, then we have not supplied at all, for which there is no formal order is ever done. It's a 40 years of transaction under the same arrangement. Then defendant 1 replied at Cuttack to the letter that is above. Plaintiff served at Cuttack letter dated 20th of February 2023 and the 20th of March 2023 to defendant 1 requesting at Cuttack to clear the outstanding dues. Your lordships should remember, I was arguing that I have replied back to this letter, that is replied at Cuttack only. Then, in spite of the repeated reminders, request and follow-up at Cuttack. So, all the request and follow-up is done at Cuttack by his agent at Cuttack, made by visiting the place of business at Cuttack of defendants by representatives of the plaintiff, who is permanent employees of the plaintiff. Defendant remains futile. Since contract in respect of the oral purchase orders, these are all oral purchase orders because there is no orders. When the lorry comes up, then we buy at Cuttack, and claim raised therein is commercial in nature. Plaintiff filed at Bangalore. Now, henceforth, from para K onwards, your lords will see what is the action that he started at Bangalore. Prior to that, it never had any Bangalore, nothing to do with Bangalore. So, since the contract in respect of the oral purchases at Cuttack and claim raised therein is commercial in nature, plaintiff filed at Bangalore application for pre-litigation mediation, paragraph number 11 of the plaint. Now, plaintiff also filed at Bangalore a criminal complaint, and jurisdiction police have registered at Bangalore at FIR, which is now stayed by this honorable court. Contract was concluded at Cuttack at Bangalore. Supplies were made at Cuttack from Bangalore. Suit at Bangalore is one of the recovery of so-and-so as enforcement of the invoice prepared and delivered at Cuttack. The entire business transaction had taken place at Cuttack on faith and belief with the plaintiff's father, though they are locally engaged at Cuttack agent and representative only, who was solely responsible for dealing at Cuttack with the fruits supply. Then business was going at Cuttack under mutual understanding at Cuttack with a local agent deployed at Cuttack by plaintiff's father. Then defendants were running at Cuttack their business only through their local representative at Cuttack. Trade only has taken place at Cuttack by his representative at defendant's place at Cuttack. At no point in time, defendants have sent order to Bangalore for procuring grapes. Rather, plaintiff always had approached at Cuttack defendants at his shop at Cuttack personally through his local agent at Cuttack. Now, these are a summation for my lord's consumption, that how to show that barring this suit or the criminal case they have filed, which is now stayed on jurisdictional aspect, there is no activity whatsoever. And the two reference at page number 1, your lordships have referred the two document. One is the invoice and second is the communication. Invoice is actually the page number 52 to 59 of my suit, which he is seeking enforcement, where there is a phrase is there, subject to jurisdiction. So there are one instrument which only refers to Bangalore as the address. Now, whether a mere letter containing an address without having anything to do with that of any action per se is a part cause of action. This is point number 1. That's my submission, which I'll show to my lord a judgment to this effect, saying that even a reply received to a legal notice or any demand which becomes the enforcement of a suit cannot become the subject matter, cannot satisfy the test of 20C. I'll show that straight away. Your lordships may kindly turn to page number 31 for a moment, 36 of my review petition. Yeah, this is page number 37 below. ONGC versus Utpal Kumar. That is, this is a table, a compilation for my lord's assistance. Page 37, paragraph number 4. My lord has it. Oil and Natural Gas Commission. This is of judgment of 1994, Supreme Court judgment. 1994, volume 4, SCC 711. My lord has it.
This is ABC laminate.
Well, that starts at the serial number 1. If your lordships go down below, the serial number 4 judgment, at page number 37, ONGC with a heading, judgment that is on the reply of the legal notice does not constitute the cause of action. My lord has it as the heading. Now, ONGC, what the Honorable Court has said.
You have to give me a complete copy of the judgment.
I have
not like this.
Yeah, I have already given it. I'll give it, my lord. If at all it has not gone to my lord, then I'll give it. I'll compile it. I'll give it.
Yes.
This is a six judgments which I'm relying on, which I have actually relied that point in time. I've given at that point in time. It's a compilation. I've given it, my lord. That's why I said that it is not being factored. That's why the review jurisdiction. So what is the proposition, my lord, here? Merely because Nico read advocate advance at Calcutta and submitted offer from Calcutta and made representation from Calcutta, these would not constitute facts forming an integral part of a cause of action, as also the mere fact it sent the fax messages from Calcutta and received a reply thereof at Calcutta would not constitute an integral part of the cause of action. So in other words, my lord, the jurisprudence as we stand today, and there is a category of decision, I have only identified 2 for my lord's assistance. In a process of, my lord, while we test the section 20, read with, my lord, 16, 17, 18. Actually, my lord, your lordship says section 60 talks about the subject matter of the suit. And subject matter of the suit can be a property, a movable property and property. So the location of the property, whether it is a movable property or immovable property, and that property is the subject matter of suit, then your lordship will test the jurisdiction accordingly. Now, what this section 19 talks about, when there is a wrong happened to somebody, a party or a property, then there will be a suit. When that suit is filed for a wrong, then that should be the location of the wrong has to be tested as a, well, not the jurisdiction. And that is how when your lordship will see the 20C, 20AB talks about the residence at the place of business of a respondent, while the C talks about the part of the cause of action. Now, how do your lordships read the cause of action? That's assistance your lordships have to take from 16, 17, 18, 19, which talks about the 2 incidents. One, that the subject matter of the suit. Now, in this case, my lord, what is the subject matter of the suit? Subject matter of the suit is the delivery of the goods, recovery of the goods, enforcement of the invoices. And these are all happened there. And then your lordship see the wrong, section 19. The moment there is a wrong happens, my lords, then the wrong has to be seen where the location of the wrong. That's a section 19 test. So when your lordship see the cause of action, quote unquote, for the purpose of the section 20C, your lordship will see the guidance from there. And these are the judgments in the reiteration of that. Now, besides that, I don't want to, my lord, burden your lordships. Subsequent to that, another judgment, I don't want to do that. I don't want to burden the court. Now, there is another judgment, my lord. Invoices are contract. That is at the, underneath that particular, the serial number 6, Jatin Kotija. Where, my lord, it has stated that in invoice, which becomes the part of the enforcement of a suit, then that has to be seen whether it is a contract or not. Because your lordships know that the contract can be also a oral contract. Now, in my case, look at this, my lord, in my case, it is actually an arrangement. It is actually an arrangement for last 40 years. Never ever in the history the respondent has ever filed any case in the Bangalore with respect to any of these 40 years of relationship. Every of the actions, including the employee appointed there, everything, including this invoice, my lord, it was actually handed over there. It never been said either through email also. It is not their case at all. So, to the extent of this proposition, my lord, I say that there is absolutely no cause of action. Therefore, to the extent of saying that the Patel brother will come saying that ouster the jurisdiction, if at all the Bangalore has no jurisdiction, where is the question of ouster? So, now the proposition, now my proposition. What I say, my lord, this is a mercantile document, as I have explained to your lordships on the last occasion, section 22, Commercial Courts Act. Commercial disputes, and what is defined, my lord, to 1C. My lord, may I just have a look at it for a moment. It says, any disputing arising out of, I'm just reading it for my lord's satisfaction. Any dispute arising out of any ordinary transactions of a merchant or a trader with respect to a commercial mercantile documents, comma, its enforcement, comma, its interpretation. That's called the commercial disputes. And what is this document? Defined under 21F. My lord may just read it for a moment. Any matter recorded on any substance by way of a letter or number or mark or combination thereof for the purpose of use of that matter, recording that matter. So in other words, this invoice, as far as this new law is concerned, this invoice is actually a mercantile document. As far as the new jurisprudential legislative principle, it can be independent of any contract, it can be enforced. So the moment it is getting enforced, whatever the content written out there, even though your lordship should read the judgments of 1958-59 to the extent say the ouster of the jurisdiction at all, if at all the Bangalore is the jurisdiction, but I have demonstrated, my lord, absolutely there is no cause of action. Now, I'm only proposing a little submission for my lord's consideration that in view of this new proposition of law that has come with effect from the 2015 Commercial Courts Act, there is a little change of law to the effect if a commercial document or a mercantile document can be a subject matter of a commercial dispute and can be enforced in a court of law. And when we apply the jurisdictional aspect of law, then that instrument should be treated as a contract. And merely because there is no specific contract absent, that does not negate the fact that it is not enforceable. So that is the second proposition. And a substantial point, my lord, if your lordship may kindly turn to my written note for a moment. I've argued the first pointer, that is SNS. The second pointer, what I've given them the distinction. I don't want to again argue because I've already said that.
They have filed the suit before the commercial court, isn't it?
My lord?
They have filed the suit before the commercial court.
Correct.
Yes.
Now what my submission, my lord, the legal propositions, just I wanted your lordships, as I've started by saying that error, mistake or error apparent on the face of the record or any other sufficient cause are the two phrases used in order 47(1 includes non-consideration of the grounds. That's a proposition which I try to borrow from the SNS mineral. I say, my lord, if this procedure may be adopted as a jurisprudential scale, notwithstanding the body of law and the review law, then in that event, my lord, it will reduce the court's burden. That's my assessment. I have examined it. I can demonstrate it if at all I go through each of the judgments. But this is a proposition for my lord's consideration. If your lordships propose that, I will be in the position to assist that court by showing that whatever the judgment still now in the review jurisdiction has been developed on the 47(1, it does not negate this jurisprudence which I am submitting. And it will reduce the court's burden. Your lordship can also, in the process of developing the jurisprudence, can also prescribe a accountability to the parties concerned. If somebody is coming to the court on a review, just because a court has inadvertently missed out on a ground, should not be unnecessary burden on the court. There should be a strict conditions can be imposed, because neither under the legislation of CPC nor under any other law, which it truncates the power of the court to undertake a review, because the section 114 only reads.
No, you don't have to labor on that aspect of the matter now.
Yeah.
Please make submissions on the grounds that you have raised.
I have already, my lord, said that the paragraph number 2 of my written note.
Yes.
And the paragraph number 3.2 and 3.4 of my review, which gives the distinction in a comparative scale that these are my grounds. The court did not factor that.
Patel Brothers was rendered in a situation where Commercial Courts Act was
not there,
had not come.
Correct.
That is your submission.
Correct.
That
I
understood.
No.
That I understood.
No, that is not my submission.
Because the definition of the word commercial disputes would also take into consideration any mercantile document,
correct,
which includes the invoice.
Correct. That's my case.
Therefore, that was a situation where this kind of a definition was not available.
Correct. Right.
And therefore, it was rendered under those circumstances. Now, in view of the Commercial Courts Act and the definition of the word commercial dispute,
correct,
since the case is based on an invoice.
Correct.
I understood that.
My point is, first summing up. Now I'm summing up.
Yes.
First ground, my lord.
Sir, even otherwise, what is running in my mind, I'll tell you. It is not enough if you simply say it's a commercial dispute. A case in Patel's Brothers was rendered prior to the Commercial Courts Act coming into force. And the view taken therein was on the basis that an invoice cannot be a contract between the parties. Here it is a contract, but still it is not going to be of any use for you.
I'll tell you, my lord.
Because like what you have stated in your invoice, that the jurisdiction is restricted to Cuttack.
Yes.
In their invoice, they have said jurisdiction is restricted to Bangalore.
Bombay. In that case, it is a
Not there, sir. I'm talking of the present case.
Correct. Okay. Okay. Please.
Understood?
Please.
But then, please read the latest judgments of the Honorable Supreme Court in the matter of arbitration, where they have clearly held the jurisdiction can be vested in a court with mutual consent of the parties.
Absolutely. But it cannot be beyond the
question here
15 to
is
20.
Question here is, can this invoice be considered as a mutually agreed jurisdiction vested in a particular court?
No, my lord.
Not
That's
possible.
not the facts of the case. Just a
possible.
small correction.
Yes.
What I'm saying, my lord, that they say that the jurisdiction bank
has to be mutually agreed.
My lord, ABC laminate.
It is permissible for parties to agree to vest a jurisdiction in a particular court.
One out of all the
more particularly in respect of movable properties.
Right.
In respect of immovable properties, Supreme Court has said even the parties cannot remove the jurisdiction.
That is the ABC laminate.
Right?
I agree with them.
Therefore,
I'm on that.
Can you consider this invoice as a mutually agreed vesting of a jurisdiction in a particular court? No.
My lord, your lordship did not decide on that scale.
You have said it is Cuttack, they have said it is Bangalore. So there is no mutual agreement.
My lord, your lordships, please, I'm just looking at your lordship's reason. Your lordships have said that merely because this phrase, quote unquote, subject to Cuttack jurisdiction, does not oust a lawful jurisdiction, which doesn't make out a contract, right?
Correct.
Lawful jurisdiction. Yes. In other words, your lordship is presuming that the Bangalore has a jurisdiction.
Not the question of presuming. Your argument is that it's a legal document in terms of the definition given in the Commercial Courts Act, and therefore it is a commercial dispute, and this is a document
enforceable, yes,
which can be taken as a contract between the parties.
Interpretation.
However, in the matter of vesting jurisdiction, unless there is mutually agreed vesting of a jurisdiction in a court,
to one out of
this
many.
document cannot be considered as a mutually agreed vesting of a jurisdiction in the court. That is not possible.
No, to one out of many, my lord knows that 16 to 20 talks about the jurisdiction. That's the law of the land. Now, if at all a particular location has the jurisdiction as per the 16 to 20, then the question of a private consent comes up. A private consent can oust a jurisdiction by a consent, your lordship says.
Correct.
So my case is, the Bangalore doesn't have a cause of action at all, 20C. How? Because the instrument your lordship is talking about two. One is the invoice and the second is the communication. These are only referring an address. Now, suppose, imagine that particular invoice gives actually New York as an address. By merely because an inscription of an address, does it create a jurisdiction as per 16 to 20? That's my limited point. Therefore, I say, when we talk about the Patel brothers came to a finding, positive finding on 20C, saying that the cause of action happened both at the Bombay and the Chennai. Now, here the parties, the Bombay party said, no, I want to restrict it to the Bombay because I have said subject to the Bombay jurisdiction. The Chennai,
not only because it is written like that in the invoice.
They
are saying the material is sent from Bangalore.
No, my lord, that's no way.
Not because of the invoice or the writing in the invoice.
My lord, there is
material has been transferred from Bangalore.
My lord, if
by the
your lordships, let us read the plaint.
Material.
Let us read the plaint, my lord. If that is written, my lord, I am out of the court. I have said that 3.4. I have given the para number. I can read the relevant paragraph. Your lordship permit me, then I'll read from the plaint and also my defense, 711. So what I'm submitting is that actually, admittedly, I said that admitted, it's not even dispute. That's why they have not even disputed it. They have not even given a counter affidavit. They even refrained from filing a reply. From the recordings of this, they themselves say this is an oral order. It is not even any kind of order. They say oral order. What they do, what is the arrangement? Look at this. For 40 years, throughout India, doing business with, and they are looking When it comes to recovery, they go there.
It is supply of grapes, isn't it?
Grapes. For the recovery of the dues, they go there, my doorstep.
Sir, it has originated from Bangalore.
No, my lord, that's not the case.
From where do they send the grapes then?
My lord, they are
Where
not
did they
only,
send the
they are
grapes?
not, please appreciate one thing. They are not only dealing with the grapes, this one is a grape. They are dealing with the multiple fruits. One of the grapes is a Bangalore. Now, suppose they are sending it from Bangalore, but actually they are giving it at my doorstep directly without me placing any order. It is just that it is, they bring the truck. Every day the truck comes up as a matter of routine. We take it a portion of it, then we sell it and they pay it. That's the arrangement. Suppose one day a truck doesn't come because of the strike or something. It is not like we have ordered beforehand. They have not given a document to show to the Honorable Court. We have given ever any order. There is no placing of an order. There is not even a shred of document. Only 8 documents. Page number 52 to 59, which is the documents out of the 5 class of documents they are given in the list of documents. These are my invoices. Beyond that, there is not even a single shred of document. Not even their case that these particular invoices were even sent by the courier or by the email. It is given to their agent there, the employee there at the Cuttack. So there is absolutely no linkages with the Bangalore, except to the extent saying that they're resident of Bangalore. They're running the business for Bangalore. The main man is here telephoning that maybe that doesn't confer the jurisdiction as far as the 20 is concerned. Legally, 16 to 20 doesn't confer any jurisdiction. Since it has not given the jurisdiction to the Bangalore, how on earth, my lord, that will be given even by consent? Here is not even a consent. Only to the extent I say that since the subject to the jurisdiction is stated there at the Qatar, it is out of all possible, and in any case, the nature of the arrangement is such. Only one place has the jurisdiction as far as 16 to 20, that's the Qatar. There is not even a second place, and Bangalore is not. When they ask for a recovery, they go there. When they talk about harassment and putting a case here, they are doing it in the vicinity of their residence. That's not how the section 20AB talks about. That's my limited submission.
Yes, my lords. In fact, I do not know whether your lordship has the benefit of the plaint on record. But my lords, in the plaint, my lords, I have specifically stated that the goods are supplied from Bangalore on an oral order placed by them. My lords, it is, I have specifically pleaded, my lords. If your lordship...
If it's there, you please read it out.
My lords, I'll just read out.
Paragraph?
Yes, my lords. Paragraph 15, my lords, the cause of action paragraph. The cause of action for the above suit arose finally on so-and-so when the defendant admitted their liability through the reply letter. That since the cause of action arose in Bangalore, this honorable court has territorial jurisdiction to try the suit. The plaintiff humbly submits that the contract was concluded at Bangalore, supplies were made from Bangalore, hence this honorable court has territorial jurisdiction. Well, at this I have specifically pleaded, my lords. Apart from other paragraphs, I have also stated. Now, my lords, a statement was made on record, my lords, now to say that these invoices, my lords, were in fact collected by me by hand. My lords, is absolutely false, my lords, because it is, in fact, my lords, I have produced 2 letters which they sent me the invoices through registered post. My lords, those are produced as page number 44 and 45 along with the plaint, my lords. Their documents, my lords, they're already exhibited. Evidence in this matter was concluded. Cross-examination of PW1 is also done. My lords, now, apart from these aspects, my lords, since your lordship, in fact, was of the opinion while my lords passing of an order, my lords, kindly permit me to read only one paragraph of that. I will read para 10 again, my lords, of the impugned order. Now, my lords, applying the law as declared.
Yes.
My lords, of course, my lords, in the earlier paragraphs, your lordship has also culled out the facts. Your lordship has also considered all the aspects, my lords, whether this is a commercial suit or not. Your lordship has also culled out provision 2F, my lords, and looked into that. Then, my lords, paragraph 10 reads like this. Applying the law as declared by the Honorable Supreme Court, this court finds in the present case that admittedly there is no written agreement between the parties. Now, my lords, this is the crux of the matter. Now, my lords, the entire argument that we put forward was, yes, there is an invoice. My lords, if you look at definition of 2F, if it's a document, I'm not denying that whether it is a document or not a document. It is definitely a document. I have relied upon it. My lords, only the words, my lords, to say that jurisdiction of Cuttack is what is mentioned is not a consensus addendum. It is not an agreement between the parties.
That is what, my lords, has been observed here.
Yes.
Now, my lords, as your lordship sees, of course, my lords, this Commercial Courts Act is of course a new act. My lords, this kind of a clause or a letter, whether, my lords, it could be considered to be an agreement between the parties, came for consideration, my lords, under Section 7 of the Arbitration and Conciliation Act. Now, my lords, under those provisions, my lords, under the Arbitration and Conciliation Act, the courts, my lords, considered whether, my lords, an invoice which contains an arbitration clause could be considered to be an agreement and therefore a consensus between the parties. My lords, some of the courts, my lords, has held that it can't be done so. My lords, the first of the judgment, my lords. My lords, this is NSK India Sales Company Private Limited. My lords, the first paragraph your lordship says, in this case, my lords, there was a written contract, my lords.